With the consent of the respondent, I beg to mention item number 42.
43.
42. Kindly adjourn the matter for today and take up the matter after vacation.
Item 43.
Two.
2.
Two.
Okay. MS.
Suparna.
Your name,
as
please.
Suparna Bhomik. As Bhomik.
S. Bhomik. Okay. MS S. Bhomik, Learned Counsel for the petition. Applicant petition has sought for listing of the case after the ensuing winter vacation. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. The prayer is allowed to use the case after on a date to repeat the office after the ensuing winter vacation.
May I please, Your Lordship, I beg to mention item number 31 of today's list, Lordship. The matter come after the vacation. Item 31.
Okay. On the prayer of Mr. A. Ganguly, Learned Counsel for the petitioner leaves the case on 8-1.
Interim order is there, Lord.
Interim order. Past agreement shall continue. The next date of listing.
Lordship, I beg to mention for listing on motion matter, madam, on Friday, madam, 22nd.
Tomorrow.
Obliged,
May I please, Your Lordship, I beg to mention item number 52 of supplementary list.
52.
Of supplementary list. Matter may be adjourned for the day and let it be listed after vacation.
On the prayer of MS.
U. Nanda.
U. Nanda, Learned Counsel for the petitioner leaves the case after the ensuing summer vacation on a date to be fixed by the office. It is submitted that consent has been taken from the Learned Counsel for the respondent to make the prayer.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention 33 item number and 36 for withdrawal, Lordship.
33.
And 36, Lordship.
Okay. MS G. Bora,
Lordship.
Learned Counsel for the petitioner has submitted that the petitioner does not want to praise this writ petition. Wants to withdraw the bill application. Okay. Any public prosecutor? Okay. In view of the above prayer made by MS Bora, Learned Counsel for the petitioner, the bail application stands dismissed on withdrawal. Same is 36.
6, Lordship. Hi. May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 13.
Item number
13, 13.
13.
Yes.
13. 13.
Yes, your applicant.
Applicant.
Okay.
Mr. Bonik is not.
No.
Mr. ABT Hawk, Learned Counsel for the applicant, is present. MS
F. Begum.
S. Begum.
F. Begum.
F. Begum, Learned Counsel for the opposite party writ petitioner, has sought adjournment of the case for 1 week.
Yes, sir.
Okay. As the prayer is not opposed by Mr. ABT Hawk, Learned Counsel for the petitioner, the prayer is allowed. Release the case after a week on a date to be fixed by the office.
Right. May I please, Lord. So I beg to mention item number 39. Bail hearing matters. For this.
39.
This matter may be adjourned for this day.
39. Yes.
May be adjourned for this.
Okay. On the prayer of Mr. A.T. Sarkar, Learned Counsel for the petitioner, the case will be listed on 8-1.
Okay.
Lordship, beg to mention item 17, Lordship. Certain medical inconvenience.
17.
Conducting counsel could not appear, Lordship.
17. You are for the petitioner?
Yes, Lordship. Regarding private respondent counsel, I have informed Lordship, but
Okay.
state respondent will inform Lordship.
Yes, Mr. Goswami.
It is cooperative law.
Both cooperative, Lordship.
No, ZA is also appearing.
Lots.
Okay. It is Mr.
NZ Chaudhary.
M.J. Chaudhary has Learned Counsel for the appearing for the petitioner has paid for listing of the case after
It should ensuing after winter vacation.
after the ensuing winter vacation. It is submitted that concern has been taken from the learned counsel for the respondents to make the prayer. The prayer is allowed is the case after the ensuing summer vacation, on a date to be fixed by the office.
Of language.
May I please your lordship, I'm from item number 15 and 16.
Yes.
Lordship, the petitioner have engaged advocate Joshua Siki from Kohima. He could not come today for personal inconvenience. The matter may be kindly fixed for 3rd January.
3rd January. I don't know. Maybe some other date.
Oh, 4th,
Not in the first week. Maybe 10 or maybe after
10.
you. 19.
19. Okay.
Okay.
Otherwise-
Mr. Your name?
Avijit Mena on behalf of F.
A. Mena,
On behalf of
learned
Fine.
counsel appearing for the petitioners as prayed for listing of the cases after the ensuing winter vacation and Bihu vacation. First of, as the prayer, you have informed the other sides.
Yes.
Okay, as the prayer is made with the consent of the learned counsel, consent from the learned counsel for the respondents. The prayer is allowed to list the cases on 19-1.
Obliged.
For motion item number 1,
This is fixed on 11-6, my lord, for appointment of arbitrator, my lord. Notice is to be issued, my lord, at this time.
Okay. Heart, Mr. G. Sahela. G. M. Sahela, learned counsel, senior counsel assisted by Mr. M. Sahela. Learned counsel for the petitioner. This is an application under section 11 of the arbitration and 11-6 of the Arbitration and Conciliation Act 1996 as amended, seeking appointment of an arbitrator. Post of issue notice returnable on readable 4 weeks, 5 to a petitioner shall take steps for service of notice upon the sole respondent by registered post AD within 2 working days.
item number 2,
Now, the petitioners are the landholders whose land occupied by Government of India, Ministry of Road, Transport and Highways by notification dated 5 January 2023. Notification is at page 12, my lordship, annexure 1.
12 page, annexure,
One.
Page 12, annexure 1.
page 12, annexure 1.
Page number 12, annexure 1, my lord.
Okay, page number,
12, annexure, this is a notification
uh,
under section 3C also, that if any,
section 3C.
3A, sorry, your lordship, and
Any person, the power and PA. And the agreement will be prepared for. Yes,
but after that, if
no, which is the village?
village is Karaikandi and Tulak is Katigora.
And your name included or what?
Mane, I have also filed one additional affidavit showing that my land is also affected by that, my lordship.
Or
Additional affidavit,
come to page 12.
yes, my lordship.
Yes, there are many serial numbers. Which one is yours?
Page 14, I think, my lordship.
I think will not do.
Page 14, 260, 261, 64, 65,
260.
65,
Tell
66,
me slowly.
64, my lordship.
Dock
65.
number,
Dock number is 261.
there is 65,
Hmm.
261,
261 to 265 bill.
261 and 265.
265.
That is serial number 65 and 68.
60 from 64 to 69, my lordship.
Serial number 64 to
69.
that is dock number 260, 261, 262, 264, 265, 267.
So 267.
What is the supporting document?
Kindly come to page in the additional affidavit, page 65, annexure 11.
One 81 also?
Not 181.
261, 262, 263. 63 is missing. Okay.
63 is there, my lordship.
Oh no, in the notification, it is not there.
Okay, yes, ma'am.
264, 265. 267 is not there.
Yes, my lordship.
So 267 is not there.
267 is in the next page, my lordship.
Next page.
66.
This is you. What is
Yes,
your
two-
name?
two petitioners.
Selimuddin.
Yes, my lordship.
You are Selimuddin or what?
No, this is, I am Salimuddin in first applicant is Salimuddin. Next is Nandi Bahu Nath. Next one,
Nidhendu.
Nidendu Nath.
267. Nidhendu Nath. Yes.
So what happened if the things is going as per annexure 1, we have no problem. But respondent number 10 filed one application before the authorities to realign the four lane way. It is at page 44, annexure 3. Page 44, my lordship.
Is 41.
44, 44.
Okay, so.
Yes.
Then then the project was shifted, my lordship. Realigned, my lordship. Page 54, annexure 8, my lordship. They have realigned the project under political pressure as well as. To save that graveyard and that, but originally there is no graveyard is there.
Whatever a decision is taken, right?
Yes, my lordship, then
realign
now why, for that reason we are affected, my page 51, annexure 7, my lordship. A school, our land, everything is going to be affected. Page 51, annexure 7, my lordship.
Page 50.
51. This is our application. We want just dispose of this application by the respondent. Without disposing of this application, they've realigned, my lordship. another two graveyards, a school is going to be affected by this.
মানুষকে ইনস্ট্রাকশন দিচ্ছে লাস্ট অর্ডার
Before whom you have submitted,
District Commissioner,
come
circle
to
of
page 12, third para,
additional,
competent authorities, additional deputy commissioner
we
Kachar.
have not submitted. to-
Huh? Yes,
Even
Mr. Bor-
the respondent number 10 also come before this court, my lordship, which is at page 59. From relevant portion. is
Come to
from-
base 12, that additional deputy commissioner Kachar is the competent authority, right? Under the National Highway Act. He has to deal as an officer appointed under National Highway. So it should have been filed before him. He inquired DC. DC has nothing to do with. Yes, Mr. See page 54. This letter is addressed to additional deputy commissioner, competent authority. Yes, Mr. Borua. Can we give liberty to the petitioner to submit application before the competent authority to consider this representation?
Definitely,
Huh?
there's any representation only.
Representation to consider and dispose of,
This.
because additional deputy commissioner Kachar is the competent authority.
Yes,
But they have filed it before deputy commissioner.
no, it is to be filed before the competent authority.
You file it within 10 days, then he will dispose of.
They will dispose of it.
Huh?
Government.
There is a court order is also there for the realignment, page 59 law.
Right, they have realigned.
Yes.
Since they have a grievance, they have a right to agitate that grievance.
Not-
Heard. Mr.
TK Day, my lordship.
T.K. Day, learned counsel for the. So as a result of realignment, whether your land is going to be affected,
Yes, my lordship.
already affected
Yes, my lordship.
by page 12 notification.
But that time only over our land it was going on. But they have shifted 20, how far I read it back, 20 meter, they have shifted towards, realigned 20 meter towards north. Now our houses are also going to be affected. As far,
Yeah.
how far I know.
Yeah, my lord, one thing is to be submitted before that. This, if at all realignment is done by NSA authority or NSA authority, which as per changing of DPR. Now, Honorable Supreme Court has clearly said that on this point, that NSA is the authority. Which route it is to go. If at all it is goes, then they are entitled for compensation. Because it is here in a very short order. It is Nursing Rao versus National Highway Authority. Here is very says there, Lordship and Lady on Ladies. It cannot be disputed that public interest is the paramount consideration. The National Highway Authority can be said to be the best judge to decide which land to be acquired and which not to be acquired for the purpose of construction of the highways, my lord.
Well,
Okay, give me that.
well,
Please, that is the.
Let them
Yes,
make the
sir.
representation.
If their lands are going, they are affected, definitely they will get, they are entitled to
Right, but
compensation. my
still
lord.
they have a right to.
Yes, yes, definitely, my
Object.
lord, they will be entitled to
Because,
compensation.
because
But
when the
decision
notification,
regarding which
when
route
the
it will go, how it will go, it will be.
Mr. Borua,
My lord, my lord.
when this notification was issued
Hmm.
and initially 3A notification, their lands were included, survey was made, according to them, a part of their land was supposed to be acquired.
Okay.
So they had no grievance, they would be receiving compensation. Now, because of this realignment, now their houses, realignment has been made in such a way that their houses are going to be affected. Now they have a grievance.
Yes.
Now this has to be re-notified, all these things, realignment. Anyway,
And here we not.
let them make the representation.
Definitely will not.
You decide.
This authority, Kala along with us, will
Hard.
be decided.
One minute, which one is?
Page 51 is our application. My lord.
One minute.
Again.
Additional deputy commissioner is not a party, right?
No one.
It's a little bit distant, no?
Heard Mr. Ikete. Learned counsel for the petitioners.
What a comedian, है ना? Confuse of course.
MSK Phukon. Learned Central Government Council for the respondent number 1. Mr. C. Borua. Learned Standing Council, National Highway Authority of India for the respondent number 2, 3, 4. Mr.
For 6, 8.
Who is PWD? MS? M. Das. Learned Standing Council. PWD. For the respondent number 5, 7. Mr. N. Goswami.
For 6, 8.
Learned Junior Government Advocate Assam for the respondent number 6, 8, and 9. Those two. In view of the issue raised on behalf of the two petitioners hearing and with the consent of the learned counsel for the parties aforementioned respondents, this petition is taken up for consideration at the motion stage itself. It is the case of the two petitioners that they is that the petition number 1 is the owner of parcels of land covered inter alia. Where is the notification?
Notification is page 12 to 14, my lordship.
12 to 14.
Annexure 1, my lordship.
Oh, you have included another writ petition, copy of the another writ petition.
They have
writ
also,
petition.
respondent number 10 have also come
Okay,
before this court.
okay. Okay. Covered inter alia by DAG number 260, 261, 262, 264, and 265. Located, situated at village Karai Kandi Part 2, Taluk Katigora. Full stop. The petition number 2 is owner of parcels of land covered inter alia by DAG number 267 at the same village, situated same village, that is Your village is different or what?
No, same, my lordship.
Okay. Your document does not support. That is Teletica. Hmm? Orgona is different. Village is different. Hmm? Come to page 66. Hmm? Dag number 265. The petition number 2 has claimed that he is owners. He is the owner of parcels of land covered inter alia by Dag number 265 and 267, situate at same village as the petition number 1. Full stop. There is a further case of the petitioner that when the respondent number 1 published a notification dated 5/1/2023 under subsection 1 of section 3A of the National Highways Act, 1956 for building within bracket widening stroke 2-lane with paved shoulder stroke 4-laning, etc. Bracket close, maintenance, management and operation of National Highway 37 in the stretch of land from kilometer 27 plus 302 AM 36 plus 850 in the district of Kachar, the aforementioned parcels of land, belonging to the petitioners came to figure, had figured in the said notification. First up, as the survey made by the respondents authorities for such acquisition were likely to affect only a part of those parcels of land of the petitioners, they did not have any occasion to object. Full stop. It has been projected that the respondent number 11 10
Private respondent, my lordship.
respondent number 10 had submitted a representation before the respondent authorities for realignment of the stretch of the proposed project. I go to project first. Proposed stretch, realignment of the stretch, realignment of Silsor dash Badarpur dash Churaibari. Page 54. Stretch of the project at village Karaikandi Part 2 on the ground that the proposed alignment of National Highway number 37 was going to affect a Mazar, M-A-Z-A-R, within bracket Rauza Sarif, and a graveyard. Representative question again. Representative question. Huh? Response number 2. 10 কি করলো? For realignment of so and so stretch of the so and so on the ground that the prayer such request came to be considered by the respondent authorities. So the respondent number 10 had also prepared a writ petition, 5380/2023. Seeking expeditious consideration of the representation. Full stop. After consideration of the request made by the respondent number 10 for realignment, the respondent authorities, the respondent NHIDCL, respondent authorities in the NHIDCL had taken a decision to shift the realignment of the road at the stretch Silsor Bodapur Surabahi Package 2 at village Karaikandi Part 2 to save the graveyard and to save the Majar and the graveyard in view of the public demand. And the matter was duly, and the decision was duly informed to the additional deputy commissioner, competent authority, land acquisition, Kachar, on 25/9/2023. Post office. Subsequent to the said decision of realignment, fresh survey was made for acquisition of land. Post office. As the subsequent survey has been made by including the process of land belonging to the petitioner in a different way. The petitioners dwelling houses are also going to be affected. Dwelling houses standing on the aforementioned parcels of land are also going to be affected if the alignment is of the National Highway 37 is finalized as per the fresh survey. Full stop. But it has been projected that a representation was submitted before the Deputy District Commissioner, Land Acquisition, Kachar, respondent number 9, Beketor, and the Circle Officer. Circle Officer. Katigora Revenue Circle. By the petitioners, two petitioners, along with a number of other inhabitants of the locality whose land, parcels of land are going to be affected by the proposed realignment. As the said representation submitted on 9/10/2023 has not been considered till date, the petitioners have prepared the instant writ petition. Mr. Borua, Learned Standing Council NHAI and NHIDCL has submitted that it is the
Competent authority.
there is another writ petition inside the writ petition. That has made the difficulty.
There is
The petition, my
on-
lordship,
on-
they filed, my lordship. Sorry.
on the basis of that it has been done earlier.
Ah.
That's right.
It is the additional Deputy Commissioner, Kachar, who has been appointed as the competent authority land acquisition under section 3 within bracket small a of the National Highways Act 1956 by the central government. Full stop. And as such, comma, and the deputy commissioner, neither the deputy commissioner nor the circle officer
And moreover, it
has,
was informed to,
where?
my lord, sorry.
Neither the deputy, respond number 6 nor the respond number 9 has any role in the matter of realignment of the project. Full stop. In any view of the matter, such decision about realignment is to be taken by the central government in consultation with the project implementing authority, like the NHIDCL in the case in hand. That is all.
And this one, already we had informed to ADC regarding shifting to competent authority. That is my submission. Already we had informed him. It is his to go.
Decision I have already said.
No, that's right. That's why my, before saying I'm.
Decision
I
has
wanted to
already
say-
been taken for realignment. I have
Yeah.
said.
That's right.
As such, since the petitioner, since the petitioners have grievances as regards the proposed realignment, the petitioners have to represent before the competent authority land acquisition appointed for the project. So stop. Mr. Day, Learned Counsel for the petitioners has submitted that the petitioners maybe petitioners are ready to submit representations before the competent authority, Kala, before the additional Deputy Commissioner, Kachar, competent authority, Kala, for the project within given the opportunity, the petitioners would file highlighting their grievances. And if such, he has prayed that if he has submitted that the state authority shall be given, is to be given a direction to consider such representation in an expeditious manner. Mr. Goswami, Learned MS Pupan, Borwata Likido, MS Pupan, Learned CGC, and Mr. Goswami, Learned State Council have submitted in similar submitted in similar lines. Borwata Vishal Likido. As the two petitioners have claimed that their parcels of land are going to be affected by the proposed alignment of the National Highway number 37 in a more prejudicial manner than contemplated earlier by the notification dated 5/1/2023, published under subsection 1 of section 3 of the National Highways Act 1956, this court is of the considered view that the petitioners are to be given an opportunity to represent their cases before the appropriate authority, that is the additional Deputy Commissioner Kachar, competent authority land acquisition, appointed for the project under section 3A of the National Highway Act by the central government. First of, instead of, thus, first of this, therefore, the petition is disposed of. Granting opportunity to the petitioners to submit a representation before the additional Deputy Commissioner Kachar, competent authority land acquisition, within a period of 10 days from today, highlighting their grievances as regards the proposed alignment of National Highway number 37, along with all the supporting documents in support of such grievances. First of, it is further observed that if the petitioners submit any representation within a period of 10 days, the said authority, in consultation with the other authorities, if found necessary, shall consider the said representation, and thereafter, by taking into account the grievances raised by the petitioner in the state representation, and thereafter, dispose of the said representation within a reasonable time period, but within an outer limit of 1 month from the date of receipt of such representation. It is further observed that this court, while disposing of the petition, has not made any observation as regards the merits of the claims of the petitioner, and therefore, the authority competent to dispose of the representation shall consider the same on its own merits and in accordance with law.
Well, obliged.
This disposal of the repetition. This order disposal of the repetition.
Item number 3.
May I please?
Ex gratia,
Yes, Lord.
issue notice, heard Mr. S.I. Akan, learned counsel for the petitioner, A. Bhattacharjee, learned standing counsel, Revenue and Disaster Management Department for the respondent number 1, any finance. Mr. B. Gugoi, R. Bapujari, the standing counsel, Finance Department for the respondent number 2, and Mr. N. Goswami, learned Junior Government Advocate, Assam, for the respondent number 3, 4, and 5. It is the case of the petitioner that her husband, Anil Boro, died on 15/8/2019.
Lordship died on 17/8/2019. 17/8/2019.
Died
But accident.
on died on
17/8/2009.
17/8/2019 of injuries sustained in a road traffic accident which occurred on 15/8/2019 at a public place. Full stop. As the petitioner the petitioner has claimed that the petitioner is entitled to receive ex gratia relief of rupees 2 lakh as the next of kin of the deceased in terms of a notification dated 15/11/2014 of the respondent revenue within bracket relief and rehabilitation branch bracket close and disaster management department from Assam. The petitioner submitted a representation before the Deputy Commissioner Kamrup Metro, Guwahati, seeking disbursal of such notification ex gratia relief on 30/6/2022. As the petitioner has not been as the case of the as the representation of the petitioner has not been considered, representative of the petitioner for ex gratia relief has not been considered by the respondent authorities till date, when the petitioner has preferred the instant writ petition, issue notice returnable on as so and so appeared, no formal notice, extra copies within 2 working days.
Item number 4.
Lordship, we have received the instruction, Lordship. May I please-
Here is the case, my lord.
Private land installation.
They are saying that the implementation is going to be taken on private land, but there's a government land. But as per the instruction I received, Lordship. The third page, Lordship. But not also in terms of gold.
He has donated the land for the public cause.
Otherwise, my lord, this is a public scheme, my lord, and it should be convenient to and accessible to all the household in the village, my lord. And
Oh,
so-
that
so far-
water will be supplied to all, but what grievance you have? You want to donate the land? Then donate,
My lord, there is a government land.
donate.
At the center place, there is a government land.
That is there, justification is there. That is a very
Low land, your lordship.
low-lying land.
And they are the graveyard in the vicinity.
Graveyard, there were objection.
My lord, may
By
kindly come to page number
If
14.
you
There
want
is
to
a,
donate the land, no issue.
my lord, 182
Who
people of
is,
the
who
village.
is he?
182 people of the village. That means,
Don't
my lord,
bring all this village dispute to the High Court.
my lord, as per the guideline, my lord, so far the guidelines said the very objective of the
He
guideline.
has donated this land by executing deed before the yes, by notary deed that he has donated for the public cause. He has donated his part of the land for the public cause. And this is safe drinking water, this project of safe drinking water is to benefit 223 number of households under Gokulpur Tengamari village.
Out of 223 villagers, my lord, 182 villagers are protesting, my lord. They have submitted the representative before the deputy commissioners that it will not serve the purpose of the village people, my lord. So, out
Who
of,
are you to decide about this?
my lord,
You have grievance, Mr. What is buried inside this petition is that you have a grievance against this part,
yes, my
private
lord.
person. That's
Yes,
all.
Yes, my lord. Our only grievance is that, my lord, since this is, my lord, public scheme, it should be, my lord, a sanction.
Heard, Mr. M.A. Islam, Land Council for the petitioner. Mr. R.R. Gugui, Land Standing Council,
PH, your lordship.
Public Health Engineering Department for respond number 1, 2, and 3. And Mr. N. Goswami, Land Junior Government Advocate, Assam for the respondent number 4. Full stop. Para. Agor order. Second, from the projections made in this writ petition, it appears that the sole grievance of the petitioners is that the water supply
Pipeline scheme.
piped water supply scheme, within bracket, PWSS, sanctioned for the petitioner's village, that's Gokulpur Tangnamari, under the Jal Jeevan Mission program, Assam is going to be installed in a plot of land belonging to a private plot of land belonging to respondent number 6. Sorry, 6. Full stop. Mr. The Land Standing Council PHE Department on 6/12/2023, was asked to obtain instructions as regards the grievance projected in the writ petition. Full stop. Mr. Gogoi, Learned Standing Council, PHE Department, placed a set of instruction contained in the communication bearing number so-and-so dated 13/12/2023. Full stop. from the parents, from the from the set of instructions, comma, placed by Mr. Gogoi, comma, it transpires that the new piped water supply scheme, PWSS, has been sanctioned under the Jal Jeevan Mission to provide safe drinking water to 223 number of households under Gokulpur, Tangnamari village, comma, Malakhoa Gaon Panchayat, comma, Tekamari Development Block, comma, District, South Salmara, Mankasa. Full stop. It has been stated that when the Gaon Panchayat president was requested to arrange a suitable plot of land for the scheme, comma, he showed the department was showed two number of plots of land, of which one was government land, the other one was private land, within bracket donated. Full stop. On making survey, comma, it was found that the government land was a low-lying land, and government land is a low-lying, is a land. It has been found, it has been found. Is a low-lying land and has a graveyard in the vicinity. Full stop. Since burials take place very often in the graveyard, comma, the public in the locality had raised objection for starting the PWSS in the government plot of land, which involves supply of safe and quality drinking water. Full stop. As the donated land has been found to have better connectivity with the main road and more convenient for to access and to operate, the Jal Jeevan Mission scheme, within bracket PWSS, comma, the said plot of land has been selected for installation of the PWSS. Full stop. It has been further stated that the cost of drawing power connection would be less in case of the donated land, as the distance from the electric substation is less as compared to that of the government land. Full stop. It has been further projected that since the whole area is a flood-prone area and considering the feasibility of the PWSS and public objection, comma, decision has been made in consultation with the district administration, and thereafter, comma, the private plot of land has been selected for the PWSS scheme. Full stop. An affidavit an notarized affidavit sworn on 23/11/2023 of the respondent number 6 is also part of the set of instructions. First of by the said affidavit, comma, it is noticed from the said affidavit that by the said affidavit, comma, the respondent number 6 has handed over a plot of land measuring 1 katha 5 lasa out of 2 bighas, 9 lasas belonging to him to the respondent PHE department for the implementation of PWSS under Jal Jeevan Mission at Gokulpur Tengamari village. Full stop. Mr. Gogoi has submitted that he would like to bring the aforesaid facts by way of an affidavit. Full stop. In the aforesaid fact situation, obtaining, let notice be issued, returnable in 6 days. As Mr. Who is this 5?
I be the contractor, my lord. He is the, my lord, contractor who was allotted the work. He, my lord, in collision with the, my lord.
Notice returnable in 6 weeks. As Mr. Swenson, if he has accepted, no formal notice, extra copies, the petitioner shall take steps for service of notice among the respondent number 5 and the respondent number 6 by registered court will be within 3 working days. The instruction placed by Mr. Gogoi is kept.
Some interim
Public direct
consideration making, my lord.
In view of the aforesaid projections made in view of the facts noticed from the set of instructions placed by Mr. Gogoi, Learned Standing Council, PHE Department, no interim relief is called for.
I do have a short.
Item number 5.
May it please your lordship. Lordship, this writ petition is directed against the order by which the special tribunal convicted the petitioner under section 4 of the Land Grabbing Act, convicting them to undergo simple imprisonment for 2 years and to pay a fine of 20,000 each, 2,000 each, lordship, and in default for simple imprisonment for 1 year. Now, lordship, the projective case of the respondent number 2 was that one Abdul Rahim Chaudhary was the owner.
Mr. Chakraborty, I'm
Lordship.
cutting you short. I looked at it was listed earlier also.
That on that day, KPH name was
I looked at the judgment,
lordship only
both on
one
the civil side and both on the criminal side. At the time of civil proceeding also, no evidence was laid. Then after recording finding in the civil side,
That
was drawn up.
That was also not changed.
Proceeding was drawn up.
No, no.
There also, you were put.
I have to
notice,
admit,
charges were framed,
I have to admit,
and you did not lead any evidence.
I have to admit,
So
it was,
those don't. I am cutting you short.
I have
I
to
am
fairly
cutting you
admit,
short.
I have to fairly admit that it was not properly conducted.
So
But
no evidence at all.
lordship.
And prior to that,
On their
no,
evidence.
prior to that, civil suit, right, title, and interest,
Lordship,
and restoration of possession
lordship.
was decreed in favor of the
True,
respondent
true.
against you. Title appeal,
Dismiss,
second appeal.
dismiss.
So please make your limitations.
Yes, lordship, I am on page 64. Lordship, may kindly
Nothing
come to
more.
page 64.
Nothing more.
Yes, lordship. When he did not get the degree executed, whether he can recourse to shortcut method of land grabbing. That is my case, lordship. Page 64.
No, nothing more. After suit
Lordship.
decreed against you,
But
title appeal was
everything I admit, lordship.
dismissed. Second appeal was dismissed.
True.
Thereafter, on the civil side, in a land grabbing case, it was finding against you,
True,
and
lordship.
criminal side finding against you. Don't make more submission.
Lordship. Page 64.
Otherwise, I am going to.
Page 64, lordship. Page 64.
No plea, no new plea.
Lordship, page 64.
In a
I am on the evidence. I am on the evidence. Finding, lordship. Page 64, paragraph 17. In fact, Lordship, his vendor did not get the degree executed. That he admit, Lordship. I was in position long before 2006, Lordship. It was not that I entered into 2016. He projected
sir,
the case, Lordship.
all these proceedings preceded by title suit,
Lordship, but in criminal, it has to be,
restoration of possession.
but when Lordship is,
Then it was also recorded. I have seen.
Lordship, kindly peruse
Yes, I have
paragraph.
seen. If you want to point out, if you pick out one paragraph, I'll also show that the restoration of possession was done by Nazir.
Yes.
So don't make that submission, picking up one paragraph from here.
Lordship, what is,
That will not do.
Lordship, what is stated
What
in his
relief
evidence?
you want?
Lordship, what is stated in his evidence, Lordship? Lordship, kindly peruse the evidence, Lordship.
5 forums. We are not going to do it. 5 forums.
Lordship.
You lost.
Lordship, in criminal case, he has
No
to be
new
beyond,
evidence, Mr. Count.
beyond reasonable doubt. That has to be proved beyond reasonable doubt, at least in criminal proceeding, Lordship.
Now tell me what relief you want in the criminal proceeding.
There has to prove that case beyond reason. I'm entitled to get the benefit
No.
of doubt, Lord.
At this stage, what?
Notice will go, Lordship, when the execution, that part may be. stayed,
No,
Lordship.
execution is not going to be stayed.
Lordship,
Only suspension one part.
Lordship. Suspension may be stayed,
Suspension of only sentence.
sentence, Lordship,
And out of the sentence, only that part, imprisonment,
Lordship,
not about the fine.
Lordship.
5 forum you have lost.
That's true, Lordship. I have to admit it was not properly
Now, this is a read proceeding now.
true, Lordship, because there is no
Whether
alternative.
tribunal has been constituted.
There is no alternative rate that other was.
To my
it had been in
information,
appeal,
tribunal
Lordship.
has not been constituted, my lord.
Is there any additional advocate general? This is a perennial problem. Land grabbing it comes out. Because these are to be considered by the appellate tribunal.
In fact, Lordship, the land, I have the sketch map of the place, Lordship. It's a dried river, Lordship.
Whatever, Mr. Chakraborty,
The that number
in
is
5 forums you have lost.
because it was not properly conducted.
We are not
Lordship.
going to appreciate any of it.
But he could not prove also.
5 forums have appreciated.
But the evidence say he did not get possession, Lordship. Why he was getting the degree executed, Lordship?
Recorded on 2
My lord,
forums, recorded.
My lord,
Please,
decree was
please come.
executed on.
This, where is that recording? What evidence you have laid, Mr.
I didn't
Oh,
lay
what
evidence,
you
Lordship,
have
but,
laid?
but their own evidence, Lordship, their own evidence.
Okay.
Paragraph 17, Lordship.
Okay, let us see the first criminal part. Civil part, let us see. Civil part. Home.
Page 35, Lordship.
Civil part. What are the issues? Firstly, page 37, paragraph 5. Opposing parties did not adduce any evidence, right?
Lordship.
We have to proceed with that. Page 39. 4 issues. 1, finding has been recorded. You have not preferred any appeal at that point of time, right?
Lordship.
So you allowed the criminal proceeding to continue with these findings,
No.
right? Issue number 2, 1. Whether the land of title suit number so and so and the present case are same. What is the finding? Same.
Lordship.
Then page 40. From Exhibit 2, certified copy of the order dated 1/6/2016, passed by the Court of Munsif number 1 Hailakandi in title execution case number so and so, it is revealed that the dictated land was delivered to Abdul Rahim Chaudhary as per report dated 4/2/2016. This is a certified copy of the order. What more you want?
Lordship,
One more finding is required.
more aspect, Lordship. He stated that he purchased from Abdur Rahim, ABDUR, but he
That
sold
lease
it,
pendants issue has also been decided.
but he sold it,
Lease
said
pendants
Abdul,
has been decided.
Abdul Lordship. He sold it, says Abdul. Whether Abdul and Abdur are the same
These
person, that is
kind
also.
of pleas and defenses ought to have been taken before the
True.
forums, 5 forums
True, Lordship.
where you fought
Lordship.
earlier.
That I have to
So,
admit, Lordship. This
You
is
are
not-
in 226.
Lordship, that's true. But being the
I
last,
am read as I am not very
But-
much
but
aware
being-
of this land grabbing proceeding. I read earlier.
being the Lordship
And
last
after
forum,
reading, I was thinking what kind of case can be made out by Mr. Chakraborty.
Lordship.
That evidence part we are not going to enter.
No, but his evidence also not Lordship boosts confidence, Lordship.
All these findings are there. 5 forums. So it is not one.
But Lordship, this
Not
criminal,
one.
aspect has to be dealt separately, Lordship.
But
Have to beyond reasonable doubt. They have to prove their case beyond reasonable doubt.
I don't think.
Bill side, my Lordship, preponderance of
Friends, what is
probability.
the sentence? Only that part.
It is not less than 2 years, extend up to 5 years.
Paragraph, which section?
Section 4, subsection 3.
Or more, up.
And what is the sentence part here?
2 years, Lordship, the minimum.
And what about you were on bail?
Right now, Lordship, this order does not say so. Only one has been set off the lady has been set off on probation, Lordship. Because it is.
Point
final.
of sentence, convicted person. Who are the petitioners here?
All those who have been convicted, Lordship, they are the respondent.
Khaliluddin,
They are the respondent.
Roisuddin, Rashid Ali, Laki Mia, Kobiruddin, Sham. Angura Bibi,
Angura Bibi has been set off on probation.
probation.
On probation, Lord. Lordship may fix for admission hearing immediately after vacation, but in the meantime, Lordship, because the last court, because since there is no appellate forum has been Lordship formed under the Land Grabbing Act.
Only that part of the sentence,
Lordship.
simply imprisoned for a period of 2 months. 2 years, that's all. Hard. Fine, you deposit. After having lost in 5 forum,
Lordship.
you don't have any case. Hard, Mr. Yes. Yes, Mr. Locker.
They are perform.
Public prosecutor. You're a public prosecutor. He is public prosecutor. What do you say? This
Yeah.
court has a jurisdiction or not?
Lordship,
In the absence of any appellate tribunal?
Lordship.
Lordship, that has been dealt in one of the case, Lordship.
Let us-
Justice Barua said so.
No, I also say so. This court has, এটা reported হয়েছিল। Let us see. I also see. তারা আছিল, decide করে, tribunal,
The underlying portion, Lordship.
land giving,
13 number portion is there.
land giving আছে।
Paragraph 3, Lordship.
This was on the civil part.
Civil part.
This was on the civil part or what?
But whatever may be, Lordship, that
Judgment order passed. No, otherwise law says that it is 227. Read petition does not lie. There is one order already that has been settled by Supreme Court. But question is here, you are impugning the civil part as well as.
I'm not. Let me check my prayer, Lordship.
What is your prayer?
13(2) of the Land Giving Act, Lordship, it says
13(2)
of the Land Giving Act, section 13(2). The criminal part is.
I have challenged the criminal part
Oh,
only, Lordship.
criminal part.
I have challenged on
Criminal part.
criminal.
In that case, Lordship, it will go to the, it will be treated as a criminal appeal, Lordship. And that's 374(2).
Is it so?
There was criminal part for.
All right, maybe. Special tribunal have the powers of the civil court and the court of sessions. Save as expressly provided in this act. The provisions of the so-and-so interest, they are not inconsistent with the provisions of this act, shall apply to the proceedings before the special tribunal mutatis. And for the purposes of the provisions of the said enactment, the special tribunal shall be deemed to be a civil court as the case may be, the court of session, and shall have the powers of a civil court and a court of session, the person convicted of the. Might be, see section 9. It is to be treated as a court of session.
Lordship. But Lordship, section 14. Constitution of the Special Court. Entertaining disposal of appeals arising out of any judgment and order of the special tribunal by notification published in the official gazette constitute a special court for the whole of state of Assam. So for appeal, they have to constitute another special court, Lordship. If I understand correctly, Lordship.
Tribunal itself is not constituted.
Right, but it is not special tribunal.
It-
Is consisting of a chairman and 2 other members.
Yes, that
The
will be the
chairman
appellate
should
court.
be of the status of
Appellate court, Lordship.
judge of the High Court.
Lordship.
Code section 9 says, please read.
Section 9 was for the Lordship first instance.
Read.
Save is expressly provided in this act, the provision
The-
of Code of Civil Provision Solution and Code of Criminal Provision Solution, and so far as they are not inconsistent with the provision of this act. The proceedings.
Shall apply to the proceedings.
Special tribunal, this is tribunal and that is special court, Lordship. If
Huh?
Lordship, if I can understand correctly, Lordship.
Please read further. Apply to the proceedings before the special
Tribunal
tribunal.
shall be deemed to
Now,
be a
special tribunal is what?
special tribunal under Land Grabbing Act,
This one.
Lordship.
Read further then.
Shall be deemed to be a civil court or as the
And
case may be a court of session.
Next.
And shall have all the powers of a civil court and court of session and the person
Read
conducting.
slowly. Then you will understand.
Conducting a prosecution before the special tribunal shall be
For the
deemed to be-
purpose of the provisions of the said enactment,
Lordship,
special tribunal shall be deemed to be a civil court,
Lordship,
or as the case may be, a court of session, and shall have all the powers of a civil court and a court of session.
Lordship,
And the
Correct.
person conducting a prosecution before the special tribunal shall be deemed to be a public prosecutor.
Lordship.
I think it is court of session.
Then
Yes.
10-1, Lordship.
Then appeal under section 374 CRPC.
But Lordship,
Ten.
then what will happen to Lordships as 13 Lordship? 13.
Lordship 10-1 also.
Any person aggrieved by the
So
judgment-
far, appeal lies otherwise.
Lordship, lies.
Appeal lies.
But that there is no appellate forum under section
Appellate
14.
forum is not there, but that forum which have convicted you is a court of session for the purpose of CRPC.
If Lordship clarified that, Lordship, I can withdraw this because
No, this
but
point
in my
is come
in my understanding, I may
now.
be wrong. In my
Section
understanding, I may be
10-1
wrong, Lordship.
Says section 10-1 Lordship also says. This part will go for as a civil liability and the criminal part will be under CRPC.
This is proceed with the criminal proceeding.
If it is criminal procedure, then Lordship appeal 374 will come.
Lordship, section 13 did not distinguish whether it will be criminal or civil.
No,
Any
no, no.
appeal, any
No,
appeal.
no, section 10
distinguishes it.
says, 10 says. See, Mr. Chakravarti, section 10, last proviso,
Lordship,
provided also that after hearing the appeal, if the special court decides the appeal against the alleged landgrabber, in that event, charge for prosecution against the landgrabber shall be framed by the special tribunal and proceed with the criminal proceeding for prosecution of the landgrabber.
true, Lordship.
So it appears that civil side, special tribunal passes the award. Then it will wait for the appeal period. If any appeal filed before the special court, then I think it will be, if execution is stayed, then the special tribunal will not proceed with the criminal part. But I have read cursorily. But if after execution, after hearing the appeal, if the special court decides the appeal against the alleged landgrabber, then special court will proceed.
Lordship,
And so far criminal proceeding is concerned, it is CRPC. Then follow it 11, 12, 13.
Lordship.
Appeal is provided
It did
There,
not, it did
there,
not distinguish
there.
any criminal or civil procedure.
there. Separate appeal.
So separable means first one, Lordship, where one will be civil and the other will be criminal part, Lordship. And in definition part also, Lordship, the special tribunal and the special court has been defined, Lordship.
Any rules have been framed?
Rules is there, rules are there, Lordship.
Let us see. Rules are there.
Lordship, rules are there.
The question is about assuming a jurisdiction which,
Lordship.
if this court does not have, then that is a dangerous proposition.
Lordship.
This appellate rule,
Lordship,
Rule 13,
Lordship.
this talks about Order 41, Rule 1, CPC.
Lordship,
It is silent about CRPC,
Lordship.
is it not? Can you call for the presence of Mr. D. Mojumdar?
Some gray areas that there was just to be erased out.
Yes, Mr. Goswami. Call him. Or otherwise Advocate General. Some notification should have been there that till special tribunal is not, special court is not constituted, that jurisdiction will be exercised by this forum.
No.
So far civil party is concerned, 227, that is, otherwise law is laid down by the Supreme Court. There is no issue. But here is a case that criminal proceeding was conducted by public prosecutor. Provisions of CRPCs are applicable for the proceeding. The court is to be treated as a court of session. Then everything indicates that provisions of CRPC is applicable.
But when the
But
appeals comes,
since since an appellate forum is created by the Act, but that appellate forum is not constituted,
Lordship.
then otherwise we feel that it is the appellate provision should be governed by CRPC till the special court is constituted. There cannot be, the persons cannot be remediless.
Remediless, Lordship.
On merit, that is a different thing.
Lordship.
So far merit is concerned. But assuming a jurisdiction which this court does not have, that is also a dangerous proposition.
Lordship.
So unless some forum is created, we cannot create, we do not legislate. We do not legislate. It is the state government who can do it. What do you say? Okay, we'll pick up after some time. Let Mozumdar come. If Mozumdar is not available, let AG come.
Six.
What grievance you have?
Grievances, Lordship, during, because I have been
Let us
removed
see
to
your prayer.
Lordship. Yes, Lordship, I have been revoked to Lordship. Subsequently, by the High Court order dated to Lordship, 12/2023, Lordship. So I have been
Let us come
reinstated to
to page
Lordship.
14. One prayer directing an inquiry.
Lordship. Because when I was removed,
Where is your representation
representation is the Lordship.
regarding inquiry? Anomalies,
Anomaly
irregularities.
is page 32, Lordship,
30?
32 Annexure 6. And the other one is your Lordship,
Your
36.
ward member, 32 is different. Ward members of our panchayat.
36 is also there, your Lordship.
No, 32 is by ward members. You are president.
I am the
That
president.
is not your representation. That is not your representation.
36, your Lordship. Yes, Annexure 7.
That is also not a representation. President writing to secretary asking for some documents is
Yes.
not a, cannot be a foundation for seeking a direction for inquiry. First prayer, you hesitate before appropriate authority by submitting representation.
So,
We are not considering.
so this is, my lord, this is my subsequent prayer, your Lordship.
Second
But the main
prayer-
prayer, your Lordship, because when I was removed to your
Okay,
Lordship,
let
that,
them finalize it, the decision about sanction and release of the arrears.
salary, your Lordship,
Let
salary,
them finalize it within a period of 1 month.
1 month.
within a period of 1 month, your Lordship. Lordship.
Heard Mr. A. Devan, learned counsel for the petitioner, and Mr. P. Hendik, B or P?
P for Punjab.
P for Punjab. P. Hendik,
No, no,
learned
we have to-
counsel representing Mr. K. Kaur, learned standing counsel, Panchayat and Rural Development Department for the respondent number 1,
3, 5 and
3,
6.
5, and 6, and Mr. N. Goswami, learned additional junior government advocate, Assam for the respondent number 2. The petitioner has instituted the instant writ petition under Article 226 of the Constitution of India seeking two reliefs. Firstly, a direction to the respondent authorities to cause an inquiry in respect of financial anomalies allegedly committed by the private respondents, more particularly, the secretary and the vice president of
Saidora Gaon Panchayat.
Hyderabad, sir.
Saidora
Saidoria.
Panchayat. And secondly, a direction to the respondent authorities to release, to sanction and release the remuneration, or it is salary or what? Panchayat account.
It's a remuneration, your Lordship.
Panchayat account.
Arrears of the
I
remuneration.
don't think it is salary.
Arrears.
Remuneration.
I don't think it is salary.
It's remuneration, my lord.
Yes.
Where it is provided?
Well, I'll give the section.
Hmm?
Lordship, page 29 may kindly we looked into, Lordship.
Page 29.
29 of the writ petition, Your Lordship.
Remuneration.
It's a remuneration.
Disburse the remuneration uh, to the petitioner for the period from 9/1/2023 to June 2023. Poster. The factual metrics in brief can be stated as follows. The petitioner was directly elected as the president, directly elected. Under the provisions of 6(1)(b) of the Assam Panchayat Act 1994, elected as the president of Saidoria Gram Panchayat under Rupoia Anchalik Panchayat and Nagaon Jilla Parishad as per the provisions of so and so. In the general Panchayat election held in the year 2018. So, during the continuance of as the president of the Hydrori Gaon Panchayat, a requisition notice was submitted by a requisite number, 8 number of ward members of the Gaon Panchayat expressing want of confidence in the petitioner as the president of the Gaon Panchayat. Full stop. A special meeting was convened and held on 9/1/2023 to discuss the motion of no confidence brought against the petitioner. Full stop. A resolution was passed in the said special meeting after the voting process that the motion of no confidence was held to be passed in the resolution, was held to be passed against the petitioner, and as a result, the petitioner stood removed from the post of president in terms of the provisions of section 15 of the Assam Gaon Panchayat Act 1990. Full stop. The resolution taken in the special meeting dated 9/1/2023 and the consequent removal of the petitioner from the post of president of the Gaon Panchayat were challenged by the petitioner in a writ petition on WBC number 368/2023. Full stop. The writ petition WBC number so and so was allowed. After hearing the parties on the repetition so and so was allowed by an order dated 12/2023. As by recording findings that the procedure required to be adopted in convening a special meeting under the provisions of the Assam Panchayat Act 1994 were violated. The impugned resolution dated 9/1/2022. What is the last page?
Last
Was set aside and the petitioner was directed
Lordship,
to
by
be
affidavit.
stated in the office of the president of Haiduri Gaon Panchayat, Portway. Full stop.
Page 49 of my affidavit.
Para. After the order dated 12/9/2023 passed in the repetition, WPC number 368/2023, the petitioner has been restated in the office of the president of Haiduri Gaon Panchayat. Full stop. With the contention that the petitioner was illegally removed from the post of president of the Gaon Panchayat, from the period on and from 9/1/2023 till her lady or
Lady.
till her reinstatement pursuant to the order dated 2023, the petitioner represented before the respondent authorities to sanction and release the remuneration entitled to the petitioner as the president of a Gaon Panchayat. Full stop. From the communication dated 12/6/2023 within bracket of the within bracket and excess 3 of the secretary, Saidoria Gaon Panchayat. The communication dated 10/10/2023 of the block development officer, Rupoi Development Block, to the chief executive officer, Nagaon Jilla Parishad, Annex 4, and the communication dated 11/10/2023 of the chief executive officer, Nagaon Jilla Parishad, to the commissioner, Panchayat and Rural Development Department, Rural Development, Assam, Annex 5, it transfers that the matter regarding sanction and release of remuneration of the petitioner for the period from 9/1/2023 till reinstatement has been considered at different levels, and finally, the matter has been forwarded to the commissioner, Panchayat and Rural Development, Assam, on 11/10/2023 for final decision. As no decision as the matter regarding sanction and release of the remuneration of the petitioner has not proceeded further, the petitioner has preferred the writ petition. seeking the relief, indicated above. Also. Seeking the relief indicated above. Also. Insofar as the direction sought for by the petitioner regarding to cause an inquiry into the alleged illegalities committed by the secretary and the vice president of Haiduri Gaon Panchayat is concerned, it is noticed that the petitioner has not represented about such alleged illegalities committed by the secretary and the vice president of the Haiduri Gaon Panchayat before any of the authorities, before any authorities, before any authority in the Panchayat and Rural Development Department at any earlier point of time. In such view of the matter, the relief sought for in the form of a direction to cause an inquiry into the alleged illegalities cannot be countenanced. Insofar as the direction sought for regarding sanction and release of the remuneration to the petitioner as the president of Haiduri Gaon Panchayat from the on and from 9/1/2023 till her reinstatement as the president after the order dated 12/9/2023 passed in the petition, so and so. It is this court deems it fit and proper to observe, but no, it is noticed that the matter regarding sanction and release of remuneration has reached the office of the Commissioner, Panchayat and Rural Development, Assam. In such view of the matter, this court deems it proper, deems of the considered view that instead of keeping this petition pending, this court deems it appropriate to instead of keeping it would be opposite to direct a commissioner, Panchayat and Rural Development, Assam, to take a final decision as regards sanction and release of the remuneration of the petitioner as the president of so and so for the aforesaid period within a period of 1 week from today, 1 week from the date of receipt of a certificate copy of this order from the petitioner at his office. It is accordingly ordered.
The period may be noted, my lord, 9th of January 23, because it's not there in the representation.
9/1/2023. I have
To June 23, my lord.
9/1/2023 till her reinstatement.
Yes.
Till her reinstatement. Pursuant to the direction of this court.
Lordship, I have one respectful submission before Lordship. So far, the financial anomalies are concerned, Your Lordship. So though appropriate petition has not been filed, Your Lordship, so Lordship, I may be allowed to file appropriate
The
representation.
petitioner is
At liberty, Your Lordship.
is, however, at liberty to highlight to agitate such grievances before the appropriate authority.
And the responsive authority, Lordship, will take,
Appropriate authority.
Lordship, and on filing the representation, Your Lordship, the responsive authority will take the necessary action, Your Lordship.
Which one?
Lordship, on filing the.
No, I'll not do. What kind of any
That is
allegation you will
premature.
raise, I don't know. There is nothing.
Lordship, financial defalcation or.
Land Gaming Act
Yes. Item number 5.
for the purpose of criminal side, on the criminal side, the special tribunal is considered to be a court of session, and the provisions of CRPC has to be followed by the special tribunal.
While dealing with the case by the criminal.
So for appellate provision is concerned, that one special court is to be constituted, to be headed by a person qualified to be a judge of the High Court, plus other things. That has not been constituted by the state till date. So for civil side is concerned, otherwise 227 is applicable. But in the absence of any tribunal, appellate special court, whether a writ petition will be maintainable or a criminal appeal will be maintainable.
Yes. In this regard, there are few judgments of this honorable court, my lord. Lordship will give me some time, my lord, so that.
Those are regarding the civil side.
My lord. Yes.
Not
criminal side.
On the criminal side.
Right.
So that is a difficulty.
Lordship will grant some time so that, my lord, I can.
To my, say, in my estimation, provision of 438, section 438 CRPC was removed in the state of Uttar Pradesh. Then there is a judgment by the name Hima something, Kohli or Mishra, perhaps. I don't know. There, the Supreme Court has said that if the provision of 438 is not applicable, then one person cannot be remediless. Then 226 or 482, I have forgotten, will be applicable. So for anticipatory bail is concerned, one can move 226 or 482 perhaps. I have forgotten the ratio, but because to assume jurisdiction, we cannot legislate. And we cannot, without existence of jurisdictional fact, we cannot assume jurisdiction. So, but a person cannot be also left remediless.
Yes.
So in that case, what 226 or CRPC provisions will be applicable? If CRPC provisions is applicable, then it will be a criminal appeal.
Right.
And otherwise, jurisdiction under 226 is limited. We cannot appreciate evidence. But if it is an appeal, it is a continuation of the proceeding.
Right.
And the appellate court can reappreciate evidence. And they have been convicted and sentenced to 4 years. We cannot go on appreciating evidence, right?
Right.
Under 226. That is a difficulty. Because persons have been convicted for 4 years on the criminal side under the Land Grabbing Act. So, when can you highlight? Because they are seeking suspension of sentence also.
My lord.
They are facing jail.
Since today we are also not in a position to, my lord, to make accurate submission in that effect, my lord. So that is why, lordship, so far the interim part is concerned, lordship.
Okay, let Mr. Chakraborty come. Mr. B. Chakraborty. I think Biplab Chakraborty. He is a petition. Please inform Mr. Locker. Okay.
And other part, certainly I will address your lordship immediately after vacation.
No, they are facing sentence.
That part, that is why, madam. That part I leave your lordship. Leave to your lordship, madam. So for that,
I have to find out.
Yes, that is.
To exercise jurisdiction also.
Even on that part also.
That is why I need your assistance. Sitting here, I cannot.
Yes, yes. Now I have been told.
Do the required exercise.
Certainly, I will assist you. This court.
Please try to address it to at least something.
Yes.
Something. In the meantime, I will ask to find out that decision of the Supreme Court. Hima something. Yes, Mr. Locker, do. Okay. Okay, just wait for some time.
Yes, yes. That will be better, I think.
Yes, next.
Item number 7.
এই ধনীৰাম বসুমতাৰীৰ মোৰ এনহেন্স এক্সপ্ৰেছি আছে এইটো হৈ গ'ল নেকি হা Yes, you were required to address on this.
Well, this judgment of the division bench, my lord had pointed out the other day. Lord, let us seek instructions from the department regarding the same. Let the department take place its stand before my lord.
What stand?
Ex
What stand after that?
My lord, a lakh has been paid to him already. Now, as per the 2004 notification, the new ex gratia amount is 3 lakhs. So as per the judgment, the adjustment can be made and then.
That is a stand of the state government that has been interpreted by the division bench. What more clarification is required?
Apart from that, nothing, my lord, it's covered case.
And then?
My lord may dispose it of that. However, my lord, the department may be given a
What? No.
occasion to place its stand. I mean, otherwise the judgment is very clear. Still, if
You want to sit over the judgment? Heard. Mr. H. Taluda. জানে? আৰু এটা ডিসপোজ কৰা যায় মোৰ এটা আছিল Mr. H. Taluda, Learned Counsel for the petitioner. Mr. N. Goswami, Learned Junior Government Advocate Assam for the respondent number
1, 4, and 5.
1, 4, and 5. P. Hendik, Learned Counsel representing Mr. K. Kaur, Learned Standing Counsel, Panchayat and Rural Development Department for the respondent number 2. And who is finance? Call Mr. Gogoi, B. Gogoi, Learned Standing Counsel, Finance Department for the respondent number 1. Full stop. The petitioner has claimed that she is the widow of one late Biden Inti, an employee under the respondent Panchayat and Rural Development Department. Full stop. In connection with the election to the Karbi Anglong Autonomous Council in the year 2021. 2001, the petitioner's husband was assigned duty at Bura Hanse Police Station on 3/12/2001. Full stop. The said said polling station was under Lang Lakso was located within the jurisdiction of Howrah Ghat Police Station. In a violence took place at the said polling station on 3/12/2001. And the said violence, the violence was attributed, was found to be caused by extremists. Full stop. In the said incident, the husband of the petitioner died of injuries. Full stop. After death of the petitioner's husband, the Investigation was caused by investigation was caused. Any police station case number?
The report was submitted by, provided by the superintendent of police, Lordship.
Where is that? Before the Deputy Commissioner Karbi Anglong stating inter alia that 8 persons were killed on 3/12/2001 as a result of an attack by the suspected UPDS extremist at Lakso under Hauragat police station, and the petitioner's husband, Gram Havoc under Hauragat development block was one of the persons who died in the said accident. Post of the said report was submitted in connection with Hauragat police station case number 168/2001, registered under sections 302, 307, 326, 353 IPC Red with section 25 within bracket 1B small a/27 Arms Act Red with section 3/5 Explosive Substances Act Red with section 3 of the Prevention of Damages of Public Property Act. After submission of report, Deputy Commissioner Karbi Anglong issued a certificate on 6/2/2000, issued a certificate number page 15 on 6/6/2022, certifying that the petitioner's husband was killed by extremists on 3/12/2001 during Karbi Anglong Autonomous Council election duty 2001 in the course of discharging his official duties. Thereafter, an amount of rupees 1 lakh as ex gratia was sanctioned and disbursed to the petitioner as per the provisions of, as per the policy contained in policy framed by the state government and notified by Office Memorandum dated 9/8/1989 and Office Memorandum dated 22/9/1997 of the Finance Department and the Relief and Rehabilitation Department. Full stop. Para. The present petition has been preferred, seeking advancement of the ex gratia amount from 1 lakh to 3 lakh in view of the subsequent policy decision taken by the state government by and notified by the notification dated 22/6/2004. By the notification dated 22/6/2004, a decision has been taken to the effect that there would not be any appointment, recruitment in government stroke semi-government jobs for the next of kin of a person killed by extremist stroke terrorist and who was earlier eligible under the provisions of the Assam Public Services within bracket appointment of family members of persons killed by extremists or terrorists bracket close rules 1992. As the said rules had been repealed by a government by notification dated 22/6 by another notification of the state government dated 22/6/2004. By the said notification, the amount of ex gratia had been enhanced payable to the next of kin of a person killed in extremist violence had been enhanced from rupees 1 lakh to 3 lakh. Paragraph 3. Four. 5. Paragraph 3, 4. A reference has been made to an order dated, to an order dated 8/3/2017. According now, I can. You have filed any application?
Yes, Lordship. And even
Where is that?
there was a communication, Lordship.
Ah.
That is 25, page number 25, type copy 24, Lordship.
The petitioner had already submitted an application seeking enhancement of the ex gratia amount, and the said application was forwarded, was considered and thereafter forwarded by the Office of the Deputy Commissioner to the Superintendent of Police, Karbi Anglong, by communication dated page 24 on 1/11/2023 to cause an inquiry and thereafter to submit a detailed report as regards the circumstances which led to the death of the petitioner's husband. Well, in view of the above fact situation obtained in the case, at this court, the writ petition is disposed of with a direction to the Deputy Commissioner to examine and verify about the entitlement. Deputy Commissioner, which district? Karbi Anglong. To examine and verify about the entitlement of the petitioner regarding enhanced ex gratia amount, and thereafter to forward a proposal to the
PNRD department.
Panchayat and Rural Development Department for disbursal of the enhanced ex gratia amount, if the petitioner is found entitled as a next of kin of a person killed in extremist violence. Taking note of the rationale behind the policies so formulated, this court is of the considered view that the claim for relief in the form of additional ex gratia grant to the petitioner made in this petition as the next of kin Para, 9 to, huh? Rational. Into. Correction করে দিব রেসপন্স নাম্বার এটা না
One more submission, Lordship. That is not in my prior Lordship. Clause 5 of the notification may also be considered, Lordship.
What clause 5?
Clause 5 of the notification.
What is that?
Free education to children of the poor affected families till they become eligible to earn.
That is not the prayer.
Petitioners,
You make an application,
Lordship.
if not granted.
This is limited expiration.
That is not the prayer.
Lordship,
That's not
in
the prayer.
I have seen that's not.
Item number 8,
My lord, Mr. Chakraborty has come, my lord.
5.
One aspect, my lord. Whether the spirit of 374(2) CRTC, we can discuss on this matter, my lord. Because directly, I think, my lord, at a glance, I did not say anything, my lord. Whether that spirit can be involved.
Whether
We'll take up on some
Yes.
Lordship,
other date,
other day. But can we-
tomorrow or day after tomorrow.
Or Friday, Lordship.
If possible, Friday.
I will have a copy in.
No problem for that. But if
Question is regarding suspension of sentence.
But
in a
after all,
226 petition.
yes, after all, my lord, appropriate court will have to deal with the matter, my lord. Then only that issue will come, my lord.
In
That is why-
374, but there is a gap.
Are you,
7 years.
are you facing imminent danger of being arrested?
Yes,
Maybe, Lordship.
Hmm?
Maybe.
Or
I
everybody can
can-
make research on 3rd of January?
Yes, that is, I think that will be better.
I think
I
it
have
needs
to-
some,
I have to avoid all these days.
needs some exercise.
Like, I
because
think, my lord, 2nd of January, lordship has
Second
3rd of
is only.
January.
Third.
3rd will be, I think, first day, reopening.
That will do. Wednesday.
Yeah, fourth, my lord.
Motion.
My lord, can it be on 4th, my lord?
Fourth.
4th, my lord.
Fourth will be better.
We are only about their suspension of
My lord.
sentence.
That- Yeah.
And if try to explore the possibility of issuing a notification.
Yes,
Issuing a notification, entrusting the jurisdiction to a particular court. That till the time this
matter would have been, my lord.
court, special court is not constituted,
Yes,
that the jurisdiction will be exercised by this.
yes. If necessary, we will also take up.
You
the
find
matter
out, you
also.
explore that
Yes,
possibility.
yes.
Okay.
So fourth, my
Be
lord.
heard, Mr. B. Chakraborty. Learned counsel for the petitioner. And, B. Goswami. Learned additional Advocate General Assam for the respondent number 1, assisted by Mr. P. S. Locker, learned public prosecutor for the respondent number 1, and Mr. A. H. M. R. Chaudhary, learned counsel for the respondent number 2, full stop, as sought for by the learned counsel for the parties, list the case on 3rd or 4th?
Fourth, my lord.
Fourth.
Because
of January.
3rd will be, I think.
We'll decide on that suspension of sentence.
PS law for additional public.
Huh?
PS law for additional public.
Additional part.
তুমি এটা কপি এটা দি দিব।
Item number 8,
Chakraborty, you can furnish a copy of the writ petition.
item number 8,
There was an order passed by this court, I have been told, the report to be, because initially there was an order by this court. Report to be called for, and subsequently they given a eviction notice. So they really circumvent the order, circumvent some type of writ petition which has been filed. Because initially, if your lordship kindly see at page 35, this is the so cause which was issued, a notice which was issued to us.
Actually, we asked Mr. Talukdar, I think.
Yes, right, that's what I have been told.
Where is Mr. Talukdar?
Talukdar indicated on that day, today he will not be there, somebody else will be there.
What we said, my lord, page 35, we given a reply. So ultimately, they should have adjudicated the matter this way or that way. They kept it.
As per Chita, Dag number 141 and 146, they are government ducts. And as per Chita, 138 and 134, those are lands belonging to the petitioners.
Right.
Right. So as per survey of the Latmandal Circle Officer, hmm, 1.60 hours
Yes.
of government dag number 141
Hmm.
and about
5 hours.
5 hours covered by dag number 146 is in possession of the petitioners. And one Assam type house
Yes.
and Kin Sali Torja house is standing there on.
Right, at page 35, they have indicated. 35 and reply has been sought for. Kindly see at page 35, my lord, of the writ petition.
Hmm.
To the principal and to Sobesh Patwal, there's the petitioner. My lord, it is we here important and the applicant, now kindly see, my lord, principal of Dispur College applied for settlement of land in favor of Dispur College in respect of government land measuring 1.60 R covered by dag number 141 and land measuring 5 hours covered by dag number 146. Out of the total land measuring 6.60 R, village number 2 under in the district of Kamrup. As per report of the concerned Lotmandal, aforesaid land in his possession of so and so by constructing one Assam type house along with Tin Charlie house. So in this regard, we need to hear the matter from both the sides. The hearing is fixed on 9/9/2022. On that date fixed, we are directed to appear 11 AM in the below mentioned office along with relevant records, documents in regards to the aforesaid land. So accordingly, my lord, we file a reply at page 39. 2 replies has been filed, but they have asked in between to produce certain documents. Accordingly, my lord, we file documents at page 46, my lord, kindly see, my lord, 46. Is the additional objection reply. So, now kindly see at page 54. In view, page 54, my lord. In view of the above, the opposite party prayed for honor by please to reject the application. Principal Dispur College and further please direct concerned Lotmandal to make physical inspection of plots of land owned and possessed by the opposite party and the Dispur College to ascertain the actual facts and do the needful to hand over the land opposite party from the encroachers. So this was the prayer which was made. Hearing took place, but there was no order passed. Neither it was communicated to us. Now, in the meantime, what made us to file the writ petition? My lord will kindly see at page 61. Encroach. Page 77. Page 77, kindly see, first information was filed before the officer in charge on 22nd, 02/2023. With due respect, Lordship Gotti, we like to inform you that we are the owners and in possession of a plot of land, dag number 19, 134 and 130 new in the revenue village in the district of Kamrup. That on 21/2/2023, Dispur College forcibly closed the connecting road by putting a fencing illegally. Land which is owned and possessed by us since last 50 years. Pertinent to mention to state that the said principal Dispur College filed an application before the circle officer Dispur Revenue Circle by alleging that our aforesaid land is government land and it should be settled with them. Admitted that the said land is being possessed by us by constructing Assam type house since long. Accordingly, we have received a notice from the office of the circle officer, these two revenue circle for hearing of the case. Honorable Circle Officer, after perusal document submitted by us and after hearing both the sides in the aforesaid application for at least 2 days without assigning any reason, returned back the matter Office of Deputy Commissioner Kamrup for further consideration. Since then a matter was pending before the Office of Deputy Commissioner for final disposal, it is pertinent to mention here that we have not yet received any notice from the Office of Deputy Commissioner, nor any date was fixed by the Office of Deputy Commissioner for hearing of the said matter till date. Now, all of a sudden, on 21/2/2023, Dispur College closed our connecting approach road measuring about 5 feet road by putting fencing where the said land is a subject matter of proceeding before the Office of Deputy Commissioner. Thus, they have taken their law into their hands for illegal. It is therefore prayed kind enough to do the needful at the earliest, enable us to use the approach connecting road. Further, our staff in the Assam was saying, this is for your kind for necessary action. Now, we file a writ petition before this honorable court, and there is an order which has been passed by this court. Kindly see at page 79, my lord. 79. That is 15/3/2023. The petitioner, the third paragraph, petitioner has alleged unauthorized and illegal action by respondent in blocking the entrance of the petitioner Miadi Patta land. So as a result of the said plot of land, a petitioner have been landlocked. On contrary, so and so, submitted the plot of land petition has not been landlocked. To have a clear picture on the matter, Henry Clarence Junior Government Advocate shall obtain report Respondent 3 as regard the existence of entry and exist of petitioner to enter the plot of land covered by Doug number so and so, whether the land has become landlocked.
I have a trace map
Yes.
locating this 134, 138, and the other DUG numbers.
Yeah.
Please locate which part of entry and egress has been blocked.
We have just, I have to just mark, yes.
I cannot visualize sitting here.
That's true.
But there is a
That's
petition
why,
that
no,
indicates
that
that
is why.
this government land which is in possession is not blocking ingress and egress to your plot of land.
Yes.
It appears prima facie. So where Dispur College has put the blockage?
Yes, yes, hold a second.
Let us understand this picture at this 4 blocks. It is difficult to understand.
Madam, can I just come in? Now, please come to page 61. It is the petitioner's case, my lord. Page 61.
I have seen it. That is why.
No, what I'm trying to say, my lord. Now, by the petitioner, by their own showing, this DUG number 134 and 138.
I have understood. I have seen it.
Which are abutting the GMC road which goes in front of my house.
Which one is abutting?
No, this, my lord.
134, 138.
Yes.
Let us have.
And my lord, they want to make clearance for possessing government land. How can they come to a 226 code for that? What is the legal right violated, my lord?
Otherwise, a person having patta land in GMC is not eligible for any settlement of any other land.
Neither they are not entitled.
They are an institution.
They cannot say, they are institution.
Let us examine the land.
No, my lord, they are institution. But apparently it appears, my lord. Then when this matter was moved earlier, you cannot, my lord, there is some procedure of moving the matter. Why your lordship asked for a report? They should have taken leave of the court. My lord, maybe. I am not saying that it is not a government land. 141, 147. It is only concern is about that whether it is landlocked or not. That's only.
That is what.
It is not landlocked.
Show me
Is the end of the
where
matter, my
Dispur
lord.
College or where the circle officer put the block.
Right. That's why, my lord, what?
Let us take for
So
a
why,
moment.
my lord? That's why we said let them go. That's why our case. And they will inspect.
No.
They will say.
Okay,
But
say at what point they have put the blockage. Just
only one
indicate
thing
to
I
me
just want
that-
to know, my lord. In pursuance to order passed by
No, no,
this.
trace map. Please see.
No,
the
in
trace.
order to pursuant to order passed by report, when this report was filed, my lord, kindly.
Whether this is true projection or not,
Yes.
just I
Yes.
am asking you,
Yes.
I am not saying finality, prima facie. বলেন না? Oh, তাহলে পাঠাইছি। Okay. Okay. So that I can understand, because it appears that your 134 and 138 DAG numbers are close to one another. And as per that picture, this government DAG number is right to your. এটা copy করে দেন, If Mr. Khandelia has gone to the place, he can
I am
take
not
it.
gonna, I don't have any idea.
Just mark there.
My person, my like. I don't have any idea. Honestly, I'm telling. Let him say, if it is not landlocked, end of the matter.
Yes.
It is very honest to it.
This,
But ultimately, it appears that eviction notice only after the court's order, they should have waited. Whatever, government should have
okay,
come
that
up.
is a different matter.
No, that's what I'm saying. Honest one.
Relief or extension of time, that is a different matter.
This is in the.
Where is
It is marked by a small pen.
130.
Blue or ink,
Blue.
red, whatever. I have the
Yes.
main one. I have given you a Xerox copy to understand.
A2 sir, Enoka, A2 northern to A2 us. It is on the northern side, just in front of us. Yes, your lordship.
Which one?
The plot
Please
number, DAG number 140.
Whatever, the blockage.
Mark the
and-
blockage to mark for you, na?
Mark that.
It has been circled, already circled.
It to block question again.
Oh.
Circle to block.
That is our.
Circle has been blocked. This is what?
That is on the northern side.
Okay, give it
Northern
to
side.
Mr. Ken Chaudhary.
Yes.
This is what he has gone. I have not gone. I don't have any idea also. Just I have seen he was explaining. But
No,
that would
one
have-
part is that
Hello, that would have been-
entry and exit from your Patta land should not be blocked.
That's
One
only
part is
anxiety.
that.
Yes, that's part.
Another part is that
No,
occupation of government DAG.
We have no right. We have no right to
Government DAG.
occupy.
Those two are different. That one should not be
146.
blocked.
Yes,
That
that's
is
only, that's anxiety.
entry and exit, one part. Second part is occupation.
Yes, sir. Well, government has every right to occupy,
46.
to give the position. It's an institution ultimately. But they should not abruptly block. Is very, that's only anxiety.
Those two issues, so entry and exit to your Patta land should not be blocked.
Yes.
Right.
Yes.
And second part is occupation of government land.
Right.
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 We are trying to find out those two solutions to those
Yes.
two problems.
Yes.
Otherwise, public interest must give way to
100%.
private interest.
Yes, yes.
And when the individual is having Patta land in a city like Guwahati, as per the land policy.
Yes. No, we are.
And on the other hand, allotment is to a public institution, not to a private institution.
Private.
You cannot get an allotment. more
Had
than
it
one-
been Mr. X,
You cannot get an allotment of a land on the land policy act. Land policy act allotment is one, we are having land. Where is the question of possessing the government land? Only what we are worried about the ingress and egress. That's only problem, my lord.
Anyway, my lord, I think towards this side is the road GMC.
show me a, that
My lord, no obstruction is being created by the man. It's no obstruction. Kindly see, my lord. Yes, had it been a case, if 134 and 138 would have been obstructed by us, then they would have had a case to go. to
your
civil
entry
court.
and exit to 134 and 138.
Not done.
Yes, yes, it's a kindly see.
134 and
Yes.
138 can't be by their own
I
map.
cannot, my lord, I cannot come. I
No,
cannot go.
134 is adjacent to 138,
Yes.
right?
Yes.
As per the picture.
Yes.
Now, where is the road?
Road to talk.
My lord,
So we come,
this side would be.
kindly
left
see,
Please write road, Mr.
my lord, if
What
your
is it to
lordship
Please
kindly-
write road in that
Huh?
paper.
Etu hobo lage.
My lord,
GMC
one
road,
thing,
more than
one
etu.
second. Your lordship
Huh?
will look into it. If you see at page 61, for a moment. Kindly see for a moment 61. We will show
GMC.
that 61. I'll just show that.
Nobody has said about the road in this page 61.
So 61, kindly see
I think
61. My lord, kindly see
subject to
for a
correction,
moment.
my lord, I feel.
Kindly see for a moment your
Yes, I am at 61.
sketch map, petitioners in the top, petitioners, and on the right hand Dispute College. Here also on the below Dispute College, and on the right hand side is petitioner. So these are two, it goes like this. So if petitioner from dark number 177 has to come here, they have to cross this up to 138 and 134.
Now this petitioner 177, 234, what are these? Patta land?
These are patta land.
My lord, no document has
No
been
patta
annexed.
land.
No document. According to us, that is 141 and 146.
That was not an issue. We have documents, my lord. If necessary, we'll
If
come
that
up.
is the road, if that is a road, then there is,
Sir, to 134 and 138.
134, 8, 138, if I
My
go,
lord,
have
this
to
is
go.
subject to correction.
My lord,
This is
if
what
I
thought.
have to go to 234, my own dark number, then I have to cross that
No.
in between, and you have blocked that. That's what my case.
No, if that is the
Yes,
case, then civil
that's
suit
the
is the
case.
remedy, not 226
Yes.
petition. If that is the case, with all respect, I'll submit, my lord. It's a case for civil court.
No, my lord, 154, and there is that is a provision section is there. And they have given a so cause, they have given notice under 18.3, not 18.2. And now they
My lord,
reverted
let-
back to
let
18.3.
the
because this,
circle officer- Let the circle officer indicate the road, my lord. That will be better.
I think if the road is accessible from your Patta land,
If road is accessible,
otherwise you have said that 7 feet.
by the 138 to 177 or 177 to 130 accessible through my land, there is absolutely no problem. This is our case, it is not
Right,
accessible.
that is what.
So now,
If the road is accessible from dark number 134 and 138, your Patta land,
yes,
there will be no issue regarding
no,
that ingress and egress.
yes, that's the only difficulty that there's a obstruction.
My lord, if I can intervene, my lord, going by page 61 sketch map which has been furnished by the petitioner, by their own showing, my lord.
Which way is the road? The 61 is okay, it is before me.
Yes. So what I'm trying to say is, my lord, by virtue of page 61, it is their own case that they are having difficulty in accessing 141 from 134 and
Well, what-
38.
let-
That
And
is one
134 and 134 and 138 is abutting the road.
My
JMC
lord,
Ganeshguri
the
Road.
best, my lord, can I just put if lordship permits, a suggestion, let our petitioner's side will be there, let dispute and let the circle officer present. Let them say that this is the land, end of the matter. This is a road. So both the parties should be present, in presence of both the parties, and let him come with a report. That's end of the matter, my lord.
Hello?
No, it is good only, let us be.
Oh. My lord, I was only trying to submit for lordship's kind consideration. This is a matter lordships will not intervene, my lord. This is two serious disputed questions of fact that involved. Had it been a case, my lord, there is some certainty about my lord, they are in fact making a wrong statement when they say the patta number so-and-so is their land. Why have they not annexed any document? In fact, that is 141 and 146. They are finding it difficult because they are not able to access to 141 and 146.
No, that's
from
not the case.
134. No,
If
going by your
necessary-
map.
No, if
going by your
necessary, we'll annex that. We have. That was not a dispute, my lord. That was not a dispute. Today they are raising that. Why we have not annexed it?
No, whatever is the dispute.
Prima facie, my lord.
Two things is in the mind of the court. One is whether entry and exit
Has
to
been-
the petitioner's Patta land has been blocked.
Yes.
Secondly, second issue is their occupation over government
Land.
government land. Both can be separated.
Yes.
If the first issue can be resolved somehow, the second issue is as per law.
Correct.
Second issue is as per law, and their entitlement is to be considered as per law.
Yes.
Otherwise,
By an appropriate forum.
by appropriate forum. Second part, occupation part. So for entry and exit, if you are living there, then that should be
addressed.
somehow to your patta land. Regarding government occupation, that is a different issue.
Yes.
I'm not saying that I want to occupy the government
Right.
land.
So
I said that.
how to
why not-
resolve this?
why not- That's why I'm saying resolving is only one, what I'm saying, both the parties, along with the circle officers should be present. Let it be.
Yes, Mr. Goswami, anything he has addressed about entry and exit in this?
Yes.
Sir. The petitioners of the interest have patta land and the ingress and egress.
Which part? First page or second page?
No, no,
First page. No, okay. And the report, my lord, line about that letter dated 1912, 1, 2, 3, 4, 5, 6, 7, 8. Line about 8 from the last para of letter dated 1912. এখন নহয় নেকি? এখন দিয়া নাই।
I don't know what page, which one is submitted.
Oh. And the petitioners are not this. এখন কি নিয়ে দেখি?
This report is saying the petitioners of the writ petition have patta lands, the ingress and egress of which is not affected. The petitioners are not residing with their family over the said land, rather they are keeping possession of the government land, that is one issue. But ingress and egress is not affected.
In the patta land.
Well, let
The
me-
patta land.
No, to patta land is having a patta land. But going to the land of that particular, my own land, because it is like this, my lord. I can't go to that land, my lord.
That is a different issue. You have bought the lands in that manner.
No, what the dispute college has done it. It is like this only. That your lordship will kindly, that's
You
why I am
have
showing the
patta
drawings.
lands- You have patta lands which
My lord, let the-
connect.
My lord, let the circle,
Let us.
no, let
assume
the
for-
circle officer, but this is a report which we have not got. We don't know anything about that report. They kept quiet for so many years. They kept quiet for so many years, my lord.
Mr. Goswami, furnish a copy of
They
this
have kept quiet.
report. Right? Report, because otherwise, that suppose you are having two land, patta land A, patta land B. They are located in such a manner that you cannot go from A to B. That is not the responsibility of the state. You are in public sphere. If you have plot A and B, you have got the lands in such a manner that it is not directly connected with one another. But both are accessible by road. Is it your case that both are accessible by road, but you want to go from plot A to plot B? Is it your case?
Yes. Let me see the report, my lord. Let me see.
What is
without
the case
report, I
actually?
can't say anything.
My lord,
That
This report-
page 61, if it is truly projected, that
Yes.
one cannot go from petitioner's A land to petitioner's B lands.
Yes.
Both are patta lands.
Ah.
Assume for a moment.
then he said that.
If these are bounded in such a manner, one cannot access from plot A to plot B. But both the patta lands are accessible by road.
Kindly see page 60. Page 60.
That is too cumbersome.
19
Two Doug numbers 19 is ours.
177,
177,
238,
238 in the
Ours.
top is ours.
and 38 was this.
19 is yours.
38.
19 is yours.
mine. Yes.
19 is yours.
Yes.
Then
My lord, in the top also 177 and 238 is mine.
230?
238 on the top. 234. 234. SM is 234.
77 and 234 is near to the road.
This, no, yes, yes. But this is what we have. If it is landlocked, then we cannot go out.
No, 177, 234, there is a road.
There is a road, absolute no problem.
No problem.
Yes.
Come to 18.
Come 18.
Whether there is a road by the side.
19
19 is again our road, our land
Okay.
19.
Whether there is a road Abutting
This, no, my lord,
18 and
this is
19.
from going from 19, which is 130 and new. From going to 19, we have to go across this 177 mile, otherwise I
No,
can't
no,
go.
I am putting the question whether any road is abutting Dag number 18 and 19.
Any intersecting point is being used.
Intersecting point has been used, that's the
No, no,
only difficulty.
We use this one thing. Where simple question that whether any road is abutting Dag number 18 and 19.
No.
No.
Where is the abutting? It is intersecting, my lord.
Oh, no,
That's the whole problem.
it is intersecting with 177.
177 and
No, no, I am-
234.
My question is different. This 18 and 19 has been renumbered.
Yes, we number.
134 and 138.
Yes.
Come to page 60.
60, we are on 60 mile.
61.
61.
You have shown me 18 and 19.
Yes.
Now here the right hand side lower block is page 61.
Yes.
Whether this plot is abutted by any road. My simple question.
Yes. The Dispur Ganeshguri Road.
My lord, Dispur College,
First block on the left hand upper block.
if Dispur College.
That is
my lord,
accessible by road.
Yes.
and
As
just
from page 60.
60,
right.
yes, from
38
top.
are also accessible through road. 38 to 18 if they have
No,
to
no,
come.
no, I'll get confused. Page 61.
Yes,
Petitioners upper block.
yes,
Whether that is accessible by road.
right. Yes.
Road,
As is evident in
Great,
page
yes,
60.
one
Yes,
second.
60
Yes,
evident.
you are lordship right.
then lower block.
Yes,
This block, whether it is accessible to any road.
Yes.
which one?
Lower block-
119,
Lower block,
19.
19.
This is not accessible to any of the road except we have to go to that. It gets
whether that
blocked.
is correct.
Yes.
But one can see the method.
The intersecting point was used by both.
Don't
the parties.
intersect,
There is
don't
no
go
doubt.
to the intersection,
There-
please, I am asking you.
Other
Yeah.
than that, there is no.
Come to page 60. 18 and 19 is on the lower part. Right? Whether these are accessible to road.
Other than the, in the northern side, both are having their own lane.
Mr. Goswami, find out 138 and 138 is accessible to road. That's all.
Yes.
Other part is accessible to road. It is vividly clear from page 60.
Yes.
That's true. That's accessible.
Yes, if it is abutted by other lands and there is no road, there could be that intersection is vital for you. But this is not related to the government land under your occupation.
But if you see 60, at that relevant time, there was no government land. At page 60.
No, that is
Subsequently-
allotment.
No, that's why I'm saying, no, 140, 141 was not there. At the time of 60. Time of 60, kindly see page 60.
No, no, we are
Subsequently, they
concerned with
brought-
only ingress and egress. We'll address on
Subsequently,
the
they
other
brought-
issue later on. Ingress and egress, if it is found, then we'll.
Prima facie, my lord, from the report, it is clear that as far as ingress and egress to 134 and 138 is concerned, it is not there. No problem. But still, lordship wants to know the road. That, my lord, you will get it.
Mr. Goswami, get the instruction.
কথাটো বুজিছা তুমি? এওঁ কৈছে নাই, খালি ৰাস্তাটো দেখাই দিলে হ'ল।
One copy.
Yes, yes, sure. Mr. Goswami, please furnish the entire set.
My lord, will it be too much if we say day after tomorrow if my lord?
It will be too
Okay.
much. It will be better if you want 3, 4, 5,
My lord.
any day.
Third.
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 Okay.
হ'ব দে না?
As heard, Mr. D. Das, Senior Counsel. Assisted by G. Khandelia for the petitioners. A. Bharatsaji, Revenue 1. Mr. N. Goswami, Junior Government Advocate 2 and 3. K. Chaudhary.
For 4.
Assisted by D. Chaudhary 4. Full stop. Pursuant to in deference, sorry, a communication bearing number so and so dated 19/12/2023 from the office of the Circle Officer, Dispute Revenue Circle has been placed by Mr. Goswami in reference to the order dated 15/2/2023. Full stop. Though it is mentioned in the said report that the ingress and egress to the petitioners patta lands covered by DAG number 134 and 138 has not been affected, Mr. Goswami shall obtain clear instructions as regard accessibility to a public road from the patta lands of the petitioners covered by DAG number 134 and 138.
That's
Intermodal will continue.
Intermodal.
till then, my lord.
Till the next set of listing, release the case on
My lord,
P1.
we'll just file an affidavit of the front length. We'll file an affidavit for the front length. Before that, report.
Mr. Chaudhary also can get, Mr. Chaudhary, you can get also a report.
Yes.
Both
Yes, yes.
furnish the report to both of them. In account and acquisition. Yes.
My lord, in response to my petition, my lord, they have already inquired about the status of the land, my lord. Your lordship may kindly peruse.
What is the case about?
Case about, my lord, related to compensation matter. I have already received the compensation, but I am paid for enhancement of compensation matter along with interest. Since my land was acquired in the year.
Under which act? 2013.
Land acquired under rehabilitation.
What protection? Otherwise, land stand vested with the state.
No, my lord, I am not protected, no any protection matter, but I am claiming for enhancement of my compensation matter.
You will hesitate, all the grounds will be available. First,
Only
Mr. I alone, learned counsel for the petitioners. Mr. N. Goswami, learned senior government advocate Assam for the respondent number 1,
4, 8 and 9.
4,
8 and 9.
8 and 9. You are for finance?
No, water.
Okay, who is for revenue? A. Bhattacharya. S. Dr. A. Bhattacharya. Lion Standing Council Revenue and Disaster Management Department for respondent number 2. C. Gogoi. Learned council representing whom? R.M. Das.
Yes.
R.M. Das, Lion Standing Council. Water Resources Department for the respondent number 3, 5, 6, 7. 7.
Yes, about 9.
Yes, 7. Full stop. The case of the petitioners, briefly stated, is that there a part of their owned plot of land, covered by part, right?
Apartment.
Covered by part. Tag number 154, patta number 43, tag number 154 part, and patta number 43 situated at village Kohara Pakhar, Mauja Bhavanipur, Bojali subdivision, district Borpetta, now known as Bojali, came to be acquired for a project named paragraph 2, ME so and so. Under the provisions of the Right to Fair Competition and Transparency in Land Acquisition, Rehabilitation and Settlement Act, RECLA Act, 2013 for thought. Full stop. Where is the award?
My lord, award is at page, my lord.
Page 58, my lord. 5A.
5. no? In connection with the acquisition process, a case, LA case number 1/2016-2017 has been registered, and by passing an award under the Rector Act, 2013, the petitioners have been disbursed an amount towards compensation for the acquired land and Zirat. Full stop. Para, it is the case of the petitioner that for assessing the compensation amount, the respondent authorities had fixed the rate of the land on, had fixed the valuation of the land in the lower side. As a result, the petitioners have received a lesser compensation, a lesser amount as compensation towards such acquisition. Full stop. Aggrieved thereby, the petitioners have prepared the instant writ petition seeking inter alia a direction to the respondent authorities to reassess the valuation of the land on the basis of a notification dated 5/10/2018. Where is that?
Notification is at page, my lord. Page 42, my lord. Page 42, my lord. 42. Annexure 11.
Notification dated 5/10/2018, published in Assam Gazette on 8/10/2018, whereby, no, this is possession.
Thereafter, they have taken possession, my lord.
Not like it. Simply. Full stop. As the lands belonging to the petitioners have been acquired as per the provisions of the Rector Act 2013, the remedy for the petitioner lies in the second proviso to subsection 1 of section 64 of the Rector Act 2013, as the second proviso, as a said proviso has provided that where the collector fails to make any reference within a period of 30 days from the date of receipt of any application from any person interested, comma, such applicant can apply to the authority requesting it to direct the collector to make the reference to it within a period of 30 days. Full stop. The petitioners have stated that they have already submitted an application before the Deputy Commissioner, before the District Collector, Borpeta, on 10/11/2022, seeking enhancement of the compensation amount on the premise that a proposal for enhancing the amount of compensation was already forwarded by the Executive Engineer, Water Resource Division, Bojali Pachala, while his proposal bearing number, page 68 or say, BJLA.1 stroke 2013 stroke, right? 13/3/2013, right? As an adequate, efficacious, and statutory remedy is available to the petitioner to prefer an application before the authority under the proviso, second proviso to subsection 1 of section 64 of the Regular Act 2013. This writ petition is not entertained, reserving the liberty to the petitioner to prefer an application under the said provision within a reasonable period of time. Full stop. If such an preferably within an outer limit of 1 month from today.
1 month, my lord.
1 month from today.
My lord.
Full stop. If such an application is preferred by the petitioner before the authority, comma, the authority shall proceed to consider the consider the application on its own merits and in accordance with law. Full stop. The petitioners, it will be open to the petitioners to take the grounds seeking enhancement of the compensation amount before the said authority. Full stop. This order disposed of the writ.
My lord, limitation period kindly. 30 days, my lord. 30 days already over, my lord.
In accordance with law, so there is no limitation.
Item number 10.
You are sincere.
Yes, sir.
Heard MSB, Learned Counsel for the petitioner. And Mr. P.K. Medhi, Learned Central Government Counsel
1 and 2.
for respondent number 1 and 2. Full stop. It is the case of the petitioner that the petitioner purchased a number of Kishan Vikas Patros for a total amount of rupees 4 lakh from the respondent postal department. Full stop. The petitioner has stated that in the year 2015, she misplaced the KVPs, and in that connection, a first information report was lodged before the lodged at Polakbari Police Station, who, after causing necessary inquiry, submitted a police report on 29/5/2015. Where is that?
Yes, Lordship.
Page 11.
Reporting that the KBPs alleged to have been stolen, alleged to have been misplaced, could not be traced out. And if duplicate copies of the KBPs were issued by there will be no objection in the event of issuance of duplicate copies of the KBPs. Full stop. With the said report, the petitioner stated to have approached the respondent postal department, respondent authorities in the postal department seeking issuance of duplicate copies of the KBPs. But the petitioner has been informed by a communication dated 2011-2019 that a third person had placed the KBPs as security in the respondent number 3 bank in order to secure a loan, full stop, alleging inaction or on the part of the respondent postal department authorities in securing the interest of the petitioner. The petitioner has preferred the instant petition. As Mr. Mehdi said, the CGC has appeared and accepted notice on behalf of the respondent number 1 and 2, no formal notice, extra copies. The petitioner shall take steps for service of notice of the respondent number 3 by registered post with AD within 3. Issue notice returnable in 4 weeks.
Highly obliged, Lordship.
Item number 11.
Yes, may it please your Lordship.
Hmm.
This is a matter of eviction, Lordship, where selling surplus land.
You have been already evicted.
Yes, Lordship.
Will issue notice.
Yes.
Third, MSB Talukdar, Learned Counsel for the petitioners. Mr. A. Bhattacharya,
Yes.
Learned Standing Counsel Revenue and Disaster Management Department for the respondent number 1. Mr. N. Goswami, Learned Junior Government Advocate Assam for the respondent number 2
And 4.
4. MS Ed Chutia, Learned Counsel representing Mr. P. Nayak, Learned Standing Counsel GMD for the respondent number 3 and 5. Full stop. The petitioners, 9 in number, have projected that they were in occupation of a plot of land, described in paragraph 2 of the repetition, measuring 2 bighas, 1 kathas, 15 lasses, since they were in occupation, since a long period of time by constructing dwelling houses thereon, full stop. According to petitioners, the said lands were selling surplus land, full stop, but the respondent authorities have in an arbitrary manner evicted the petitioners from the said plots of land. Full stop. The repetitions have been preferred seeking entirely a directions to the respondent authorities to settle the petitioners in the said plot of land and or to rehabilitate them in alternative and suitable plots of land. Issue notice returnable in 4 weeks. As so and so appeared, no formal notice, extra copies.
Item number 12.
May it please your Lordship.
Hmm.
My Lord, all the petitioners were
earlier shop holders under Lanka Municipal Board. Subsequently, this sub-complex, a new shopping complex was constructed.
You have been called for an inquiry. How you are?
Yes, my lord, I participated in the inquiry.
Premature.
No, my lord, I have already participated in the inquiry. Inquiry was already held. But now, my lord, we are apprehending that any moment our
Apprehension will not do.
Yes.
my lord,
Premature. This is inquiry hearing. Simply
we are not against inquiry. We already participated.
notice.
Our only case is that.
You come when anything genuine
But in the meantime,
genuinely apprehended.
if you are evicted, my lord, there is the thing. Only apprehension is that we should not be evicted without following due process of law. Status quo may be maintained only for that.
No status quo will issue notice. If really they take steps for vacating the stalls, will interfere.
Will we remain?
Simply inquiry has been done, you have been asked to appear.
We have already participated in the
You
inquiry.
participated, good enough.
Yes, my lord.
That's all. You have been validly allotted
Yes,
lands,
we have
stalls.
already deposited 1 lakh each.
They are making an inquiry. Just because making an inquiry, they are entitled to make an inquiry.
We are not against inquiry, my lord. Only thing that we may not be evicted without following the due process of law, without any notice, without we may not be evicted.
Merely apprehension. You are jumping the gun.
My lord, they are trying to give these shops to other persons. So they have, after the High Court has delivered judgment, my lord.
Deliver judgment directing the deputy commissioner to cause an inquiry.
And the inquiry has been held. Thereafter, we got the settlement, my lord. Not before that.
Then why you are apprehending?
Because
Unnecessary adding numbers.
Inquiry, my lord. They have threatened that do this, do that, all these things, my lord.
Come when there is genuine apprehension.
In the meantime, we may be removed, my lord.
Come when there are genuine apprehension. We don't think. Just because a notice has been issued asking you to appear.
And we are not agreed by the notice. We are only apprehending that we may be removed without any further reference. That should not be done.
Where is that? Where is that?
My lord, they may evict us at any time because they have collected money from other persons. That's why without any further reference we may be disturbed. Only the status quo as well today may be maintained.
We'll consider on reopening, but till the next date of listing, there shall not be any cooperation. We'll putting it in the motion column.
Yes, Lord. Yes.
We'll dispose of this kind of premature repetition. We are not going to entertain.
Yes.
Okay. Heard Mr. N.H. Majarbuyan, learned counsel for the petitioner, and Mr. N. Goswami, learned junior government advocate, Assam, for the
1, 2, and 3.
respect number 1 and 1, 2, and 3. You get the instruction. We'll dispose of. Mr. Goswami has short time till 5/1. 5/1/2023 to obtain instructions about the inquiry process to which the petitioners have been asked, have been called for. Full stop. Let the case be listed in the motion column on 5/1/2023. Till the next date of the listing, there shall not be any coercive actions.
Yes.
Against the petitioners. We'll decide on the next date.
Yes.
So extra copy will be served. One extra.
2 extra copies of the writ petitions shall be furnished to Mr. Goswami, junior government advocate, in order to facilitate obtaining the instructions.
Supplementary list for motion, item number 49.
Yes.
My lord, your lordship asked the public
Yes.
tutor
Mr. Locker,
present.
are you aware of the?
I have controlled just.
Huh?
I have controlled. I have controlled just.
You have gone through now or ready?
My lord, can I take another approach, my lord.
No, Mr. Talukdar, we will be running short of time. There are bail applications also.
My lord.
Someday else.
Then after vacation, my lord, I will also try to find out some other way. Not immediately, my lord, on.
4-1 or
After 5, my lord.
8-1?
Yes, yes.
8-1.
8-1 will be, my lord, more convenient. Okay. My lord,
Okay.
in
Miss-
fact, if I take only 2 minutes time of your lordships, my lord, in fact, what I was trying to understand, that so far as Bhajanlal is concerned, my lord, the principles laid down under paragraph 102(3)(2), my lord, more particularly 3, my lord. 3, my lord, squarely applies. And if your lordship, my lord, in fact considers it, only one short paragraph, I'm reading it out, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. So here what the honorable court says, my lord, to prevent the abuse of the process of court. In that regard, my lord, the power under 482, my lord, also comes in, my lord, or to otherwise secure the ends of justice. So if your lordship, my lord, in my respectful submission, my lord, takes this view, my lord, that if, my lord, the FIR and the evidence collected does not support, my lord, then perhaps, my lord, I am entitled to some protection of your lordships, my lord.
Right. From that perspective, but question is, one procedure is followed. Whether it is right or wrong, that is a different thing.
No, what
They
I
have
want.
obtained some information. From a authority.
My lord.
Question is not that this admissibility of the evidence. Court is not required to be gone into.
No, what I'm on, my lord, so far as, my lord, appreciating the, my lord, evidence is concerned, that is another aspect. But if your lordship comes to this conclusion, my lord, that the materials which is collected, it is divorced, my lord, the prescription of law. And if it is not permissible at all.
Right from Mr. Talukdar,
My lord.
Bhajanlal is okay.
My lord.
So far, evidence which you have collected, right, and which you are trying to bring on record.
Yes.
To rebut the case of the prosecution.
I have not brought anything. It is the materials of the investigating agency, my lord.
No, we'll not go into this notarized.
Lordship may not go.
Everything.
Lordship may not
We'll
go.
decide
Even
yes,
if
we'll decide on whatever is there.
even if your lordship does not take into account my material,
Reserve all the submissions on the next day.
my lord, correct.
I think better.
Otherwise, Lordship, quashing of FIR, quashing of charge sheet and proceeding, they may approach in 482 petition, Lordship. Why in 226? I don't understand, Lordship.
Because the authority is in Bangladesh is involved perhaps. I don't know. Right, Mr. S.K. Talukdar, Learned Counsel for the petitioner, and Mr. E.S. Lockwell, Learned Additional Public Prosecutor Assam, and Mr. N. Goswami, Learned Junior Government Advocate Assam for the state respondents. Lays the case again on 8/1/2024. In a motion column.
My lord, deeply obliged.
Item number 50.
Lordship, this matter, Lordship wanted to have the present status as regard whether consent application has been considered or not. So there is no question of considering the application. It has been rejected a long time back. There was a public complaint based on which inspection has been carried out. And the inspection has found out that there is a very possibility of hazard being created by fire, because there is very rampant and frequent fire that catches up in the place. And finally, head office has asked the unit to totally stop down because they have been running without the proper authority from the pollution board. And this is our stand. And subsequently in the month of September, there is another August, there is another complaint, fresh complaint which has come in. And based on which we have immediately written to the APDCL to stop the electricity connection. Finally, that has been stopped. And that is the present status. And since their previous consent application has been rejected, and thereafter they haven't applied afresh. So there is no question of rejecting or accepting.
If that may be recorded and
Yes.
and if a copy could be given to
At the same time, the petitioner, if at all he pleases, he can make a complaint, formal complaint to the deputy commissioner, so that if at all.
If he is still operating.
No, he was operating after the first
No, no,
stop.
if he
stop
is,
order.
suppose he is still operating,
Lordship.
then you exited the your grievance before the deputy commissioner, then come before us.
Yes.
That is another
Yes.
matter. But so far as pollution control board consent to operate, I think that has been rejected.
Yes, that is the instruction that has come.
Okay.
That may be recorded and lordships may dispose it.
Heard Mr. A. Ganguly. Learned counsel for the petition. Forest, Mr. I. Bhattakur. Learned counsel, you are standing counsel? Learned counsel representing Mr. B. D. Gogoi. Okay, learned standing counsel, Environment and Forest Department for the respondent number 1. Mr. N. Goswami, learned junior government advocate Assam for the respondent number 2, 3,
And
8. Mr. S. Borua, learned standing counsel, Pollution Control Board Assam for the respondent number 4 and 5. Any PNRD? Mr. Goswami, you can represent 7 and 8 also. Fire Brigade, 7 and 8. In this writ petition, the petitioner has represented that the respondent authorities in the Pollution Control Board has allowed the respondent number 12 to operate
One number
a
11.
waste 11,
11.
a waste cloth processing industry in the name and style of Monsuri Cotton Industry from a plot of land, adjacent to the petitioner's plot of land.
Petitioner's residence. Plot of land is my mother's, but it is my residence.
Adjacent to a plot of land belonging to the petitioner family.
Petitioner's family.
Petitioner's family. Situate at Dekiajuli, right?
Lordship. No, the description is there, Malud, in the first title also. Village number 2,
Village
Medisuburi.
Medisuburi.
Lordship. Village number 2, Medisuburi.
Medisuburi.
Rangagora.
Medisuburi.
P.O. Rangagora, Malud.
Rongapara.
Rangagora, Malud.
Rongagora, where is?
In the cost title at page 3, Lordship.
Page 3.
Petitioner's address. This is the address.
Now village number 2, Medisuburi. Police station, Dekiajuli. Post office, Rongagora, police station, Society, district 24. Post office. It has been brought to the notice of the, it has been brought to the notice that the respondent number 11 had earlier approached this court by way of a writ petition, WPC number 5824, 2023. Projecting that on and from 1/8/2023, he had been he had been asked to stop operating the said waste cloth processing industry from the premises as he was found running the industry without any prior consent from the respondent Pollution Control Board, Assam. The said writ petition was disposed of on 14/2023. Directing the respondent Pollution Control Board PCBA কৰি দিওঁ, PCBA authorities to consider the application, if any, submitted by the respondent number 11 for grant of quote unquote consent to establish stroke consent to operate the waste or grant of so or otherwise in respect of the waste cloth processing industry in accordance with the provisions of Assam Prevention and Control of Pollution Act 1981, more particularly, Section 21 thereof on its own merits within the prescribed time period. Full stop. On when the writ petition was listed, on 18/12/2023, Mr. Borwal and Standing Council PCBA was requested to obtain instruction as to whether the respondent number 11 has been granted any consent to establish or consent to operate the waste cloth processing industry stated to have been installed near in the plot of land adjacent to the plot of land belonging to the family of the petitioner. Full stop. Ms. Borua, in deference to the in deference to the order dated 18/12/2023, Mr. Borwal and Standing Council PCBA has placed a set of instruction contained in a communication dated so and so, a number so and so, dated 19/12/2023. Post of, as per the said from the contents of the said communication, it is revealed that there was a public complaint with Sahajan Anjari. A public complaint was received from the petitioner and others on 21/7/2023, and an inspection was carried out thereafter by the officials of the PCBA on 28/7/2023. Full stop. After inspection, a report was submitted by the inspecting officials of the PCBA recording that there was every possibility of hazard fire from the unit. Full stop. It has been further reported that as the industry has been operating since August 2016 without prior permission from the PCBA, it has been further reported. On receipt of the report, the head office of the PCBA issued a letter to the industry operated by the respondent number 11 to stop operation from 1/8/2023 until further orders. Full stop. On 2/8/2023, the respondent number 11 had submitted an application for consent to establish, and the said application was considered and thereafter rejected on the basis of the report submitted by the inspecting officials of the PCBA who inspected the site on 28/7/2023. Full stop. When on 25/8/2023, a fresh complaint was received against the same waste cloth processing industry, comma, a letter was issued on 30/10/2023 to the respondent number 11 to close down the operation of the unit. And a copy of the said letter has also been issued to the APDC, Assam Power Distribution Corporation Limited, to disconnect the power supply of the said industry. Full stop. In view of the above said, or in view of such facts stated in the communication stated by the respondent PCB authorities, comma, Mr. Ganguly, the counsel for the petition has submitted that the writ petition can be closed at this stage, reserving the liberty to the petitioner to approach again in the event of any subsequent cause of action. First of, as the industry has already been, waste cloth so and so operated by the respondent number 11 has already been ordered for closure by the respondent PCB authorities, comma, this writ petition is closed as there is no surviving cause of action. Post of liberty stands reserved to the petitioner to approach again in the event of any subsequent cause of action. A copy, the communication number so and so, dated so and so, placed by Mr. Borua, is kept as part of the case record.
Item number 51.
May please, your lordship. My lord, in this case, we have filed our additional affidavit today itself, my lord. And what happened, my lord? But my lord, we have come.
Your interest will be protected, definitely.
My lord. Some new facts we have come to know, my lord, and.
Have you brought?
No, my
in
lord.
the additional
So, my lord,
affidavit?
no, my lord. So, my lord, I may be allowed to withdraw with liberty to file a fresh, my lord.
Mr. UK Das, learned counsel for the petition, has submitted that there are subsequent developments in the case, and the petitioner likes to bring those subsequent developments on record by filing a writ petition afresh. Post of. Mr. Das has thus submitted that the petitioner wants to withdraw the writ petition in order to file a fresh writ petition incorporating the subsequent events. Like Mr. CGC MS Sinha, B Sinha, VL Sinha, the Central Government Council.
No, Lordship, Standing Council, NHIDC.
NHIDC, any
Or
central,
respondent-
RDB, Central Government Council, respondent number 1, BL Sinha, learned Standing Council, NHIDCL for the respondent number 2 and 7, and J. Shutia, learned Standing Council, KAC for the respondent number 4, 5, 6. Who is 3? Hmm? 3. And Goswami. Junior Government Advocate Assam for the respondent number 3, Milari, are present. Post of. In view of the above submission made by Mr. Das, the writ petition is dismissed on withdrawal, with the liberty, to the petitioner to file a press.
Bail hearing B, item number 30.
Huh? It has, no?
Oh, sorry. 53.
My lord, the land of the petitioner has been acquired under the National Highways Act, and the compensation amount was disbursed by the competent authority Thereafter, after around 4 months later, a complaint has been filed by the private respondent number 5, saying that this land belonging to them, although no documents were served upon us. And the learned additional deputy commissioner, the competent authority passed the order, page 40.
So you are not interested to part with the money
I have already
on
taken.
the ground that it is illegal.
This is illegal and
Yes.
the Kala has become the functus
Yes,
officio. 40. The Kala has become functus officio.
No, he has the authority under 3H3.
Yes, but after disbursement.
Identifying the person,
Yes,
I think.
they have identified.
He has identified you already.
Yes,
Now he has identified the other one.
other one.
That
But,
this person is also a person interested.
Yes,
But by that time, you have received the money.
and I have apportioned amongst my brothers.
Yes. Legality and validity of this order is questioned. For the interim, Mr. Dhor,
My lord,
that there shall not be, only that part of the order by which you have been directed
my lord,
to return the award.
my lord.
Otherwise, my lord, it has to go to the authority.
I have submitted. a
Anyway, you
request.
have the indemnity bond with you.
Yes,
Yes,
Heard. But for the time being, no disbursement.
yes.
Heard, Mr. A. Dhor, learned counsel for the petitioner. Mr. CGC RDB. Central Government Council for the Respondent number 1. A. Bhattacharya, Standing Council. Revenue 2. Mr. N. Goswami,
For 3 and 4.
Junior Government Advocate for the Respondent number 3 and 4. Full stop. What is the award? Anything?
my lord, that has not been served upon us.
Hmm?
That has not
Any
been. served.
statement? Where is
Yes, ma'am.
Otherwise, it is reflected in the impugn order.
My lord, page 7,
Okay.
paragraph 6, last line. As a matter of fact, the petitioner as well as his brother have not.
a land acquisition
Received the
proceeding was initiated for acquiring lands for the purpose of construction of National Highway number 127B by registering a case, LA case number 14/2016. And a part of the parcels of land, belonging to the petitioner and his family was acquired in the said acquisition process, an award under section, this is under what act?
National Highways Act.
An award under section 3G1 came to be passed by the competent authority land acquisition Kala for an amount of rupees 13,17,943 in favor of the petitioner against the acquired land. Full stop. Well, it is the case of the petitioner that after disbursal of the compensation amount in favor of the petitioner, a complaint came to be lodged by the respondent number 5, claiming ownership of the parcels of land against which the petitioner has already, against which the award in favor of the petitioner has already been passed, and the petitioner has received the compensation amount. Full stop. It is the further case of the petitioner that taking cognizance on the said complaint received from the respondent number 5, the Kala has passed the impugn order, has passed an order dated 8/12/2023, whereby the Kala has entirely directed the petitioner to return the awarded amount already credited in the savings bank account of the petitioner within 7 days from the date of receipt of the order. Full stop. Whereas Mr. Dhar, learned counsel for the petitioner, has contended that after passing of the award, the Kala has no authority and jurisdiction to make such a direction. Full stop. On the other hand, Mr. Goswami, Junior Government Advocate Assam, has contended that even after passing of the award under Section 3G1, the Kala has the authority and jurisdiction to identify the persons influenced in terms of the provisions of Section 3H3 of the National Highway Act 1957. The issue here is whether the competent authority land acquisition appointed under Section 3A of the National Highway Act can direct an awardee to return the compensation amount after passing the award under Section 3G1. Issue notice returnable in 4 weeks. As so and so appeared, accepted no formal notice, extra copies, the petitioner shall take steps for service of notice among the respondent number 5 by registered post with AD within 3 working days. Having regard to the projections made and the issues involved in this writ petition, it is provided that the operation of that part of the impin order 8/12/2023, whereby the respondent number 3 as the competent authority land acquisition Kala has ordered the petitioner to refund the awarded amount within 7 days from 8/12/2023. Shall be kept in advance till the return.
Item number 54.
My lord, the issue is covered by 2 earlier orders. One order we have annexed, my lord. My lord, if your lordship will kindly come to the Supreme Court's orders at page 180 and the operative portion is at 181. My lord, this SLP was filed against the order passed in that PIL of 2018. The principal
we have a
grievance-
copy. Yes. Yesterday we got the copy.
Yes.
PLO copy to some. The
The principal.
That one. Pradyut Kumar Bora.
Yes.
Day before yesterday, matter was come, item 50.
Okay, we had the order.
Principal grievance of the petitioners before this court is that preemptory direction have been issued by the High Court, which are likely to be construed as having been issued after recording finding of fact, that petitioners and similarly placed occupants in the concerned area are unauthorized occupant. This apprehension, in our opinion, is misplaced, for the tenor of the order, which is impugned in this special leave petition, is merely to direct the Deputy Commissioner to proceed against the unauthorized occupants in accordance with law, which presupposes that Deputy Commissioner must examine the claim of each occupant on case-to-case basis, and after recording satisfaction in the light of the evidence produced before him, proceed to pass appropriate order as per law. We may add that if that order is adverse to the occupants, the Deputy Commissioner must give a reasonable time to the occupants to take recourse to appropriate remedy as may be permissible in law. In other words, the Deputy Commissioner shall decide the proceeding uninfluenced by any of the observation made by the High Court in the impugned judgment and order. It will be open to the Deputy Commissioner to request the High Court to extend the timeline specified in terms of the impugned judgment and order, with request we are certain would be considered appropriately by the High Court. So, my lord, basically, my lord, For example, in the present impute notice, there are 56 notices, my lord, of which 30 are before your lordships. Now, in terms of the Honorable Supreme Court's order, we have annexed one order at page 183, my lord. And the operative portion, lordships will get at page number, my lord, 186. Or rather 187, my lord. The last two subparas, since the proposed eviction drive is evidently initiated in terms of the order dated passed by the division bench in PL, hence observation and directions contained in the order dated 3/20 of the Supreme Court of India, in the opinion of this court, will be applicable in case of the present petitioners as well. As such, with the consent of the learned counsel for both sides, the writ petition is being disposed of at the motion stage. Hearing by providing that till 31/8/23 to writ petitioners to submit individual representation before the respondent Deputy Commissioner Baksa, ventilating their grievances in the matter. If such individual representations are submitted by them in the time prescribed by this court, same shall be considered on merit and disposed of by separate orders issued in the light of the observation made by the Supreme Court. So, my lord, it can't be an en masse order or something. Individual cases will file objection, my lord, they will consider.
Within the time frame, they will file individual applications.
15 days from today?
Yes.
Thereafter, Deputy Commissioner, case to case basis.
They will
And they will inform the parties as directed.
What are the impute notices?
Yes, page number, my lord. Page 175.
Last one is 170.
Okay.
It contains 56 names, my lord, but only 30 are before your lordship.
178 last.
Third, Mr. K. Chaudhary. Learned Senior Counsel, assisted by Mr.
TR Sen.
T.R. Sen. Sen. Learned Counsel for the petitioners. A. Bhattacharyji.
7.
Learned Standing Counsel, Revenue Department for the respondent number 1. R.B. Bora, Learned Standing Counsel, BTC for the respondent number 2, 3, 4. Mr. N. Goswami, Learned Junior Government Advocate Assam for the respondent number 5, 6, 7, and 8. The petitioners in this petition have projected that they are permanent residents of the village Potsim Padragaon, which is within the district of Bongaigaon. Full stop. The petitioners have further stated that they are living in the village since the time of their predecessors. And their names as well as their predecessors' names are were recorded in the electoral rolls since a long time. It has been further stated that the petitioners have been living in the said village by constructing permanent semi-permanent structures dwelling houses in the respective plots of land under their occupation. The petitioners have approached this court when they have been served recently with a notice termed as final public eviction notice dated 6/12/2023 by the Circle Officer Sidley Revenue Circle. Full stop. in the said final eviction notice, comma, names of 56 number of persons, including the 38 number of
30, my
petitioners,
yes,
38.
30, my lord.
30. 30 number of petitioners hearing have figured. Full stop. As per the said final eviction notice, comma, the petitioners have been found occupying a part of government land measuring 186 bighas, 3 kathas, 15 lesas, covered by DAG number 487 and the Sidley Revenue Circle. And by the eviction notice, said eviction notice, comma, the petitioners have been asked to shift from the alleged encroach area within 15 days, within 15 days. Full stop. The petitioners have further it has been stated by the petitioner that the final eviction notice dated 6/12/2023 was preceded by a notice termed as public eviction notice dated 5/8/2023, wherein the names of same 56 number of persons had figured. So Mr. Chaudhary and senior counsel for the petition has stated that on an earlier occasion, comma, number of similarly situated persons had approached this court by way of a petition, comma, 4797/2023. And those petitioners have been granted opportunity to represent their respective cases before the concerned district commissioner. As per the observations made in the order dated 21/8/2023, whereby the said petition was disclosed. Mr. Chaudhary has further drawn attention to an order dated, what is the date? 3/2/2020, passed by the Honorable Supreme Court of India in special leave to appeal, within bracket capital C, D number 2121/2020, which arose out of an order dated 9/12/2019, passed by division bench of this court in PIL number 78/2012, right? The PIL, PIL number 78/2012 was preferred, alleging that no, it is Pradyut Bora. Within bracket, Pradyut Kumar Bora versus
State of Assam and others.
was preferred. Hesitating that tribal belts and blocks
Land in
Had-
tribal belt and blocks are being occupied by non-tribal.
were created to protect land ownership of people belonging to tribal and backward classes and to ensure that encroachment does not take place by outsiders. Full stop. Projecting that encroachment of land by outsiders has been allowed to continue unabated despite the provisions of law contained in Chapter 10 of the Assam Land and Revenue Regulation 1886, comma, protection of those lands have been sought for. Full stop. It was in that context, comma, the division bench had passed an order on 9/12/2019, observing inter alia that the provisions of Chapter 10X, 10 to X of the Assam Land and Revenue Regulation 1886 are required to be implemented, and the deputy commissioners are required to take utmost care while according permission for transfer of land within the protected belts stroke blocks. Full stop. A direction had been passed to the concerned deputy commissioner and other related officers to strictly implement in letter and spirit the provisions of Chapter 10 of the so-and-so Regulation 1886 and the areas in illegal occupation of non-tribals and other persons who are not eligible to hold possession of land be evicted after following due process of law. That is what.
Yes, yes.
Okay.
That's been
When
reiterated by the Supreme Court.
that, when? The order passed in SLP number 2121/2022. Sorry, the special leave appeal, SLP, so arose out of the said order dated 9/12/2019 passed in PL 78/2012 by the division bench of this court, full stop. And in the said SLP, comma, the order dated 3/2/2020 was passed. The operative part of the order dated so and so reads as under page 181.
Yes, ma'am.
The para start from the principal grievance.
Principal grievance, yes.
And we are extracting up to by the High Court,
Yes.
right?
Ma'am.
Besides this, we are not extracting.
No, ma'am. Correct.
Full stop. In view of the said direction passed in order dated so and so in the PL number so and so and the order dated so and so by the Honorable Supreme Court of India SLP number so and so, the writ petition WBC number 4797/2023 was disposed of by an order dated 21/8/2023. Allowing the petitioners therein, who are stated to be similarly situated like the petitioners herein, to submit individual representations before the
District Commissioner.
jurisdiction and deputy commissioner, ventilating their grievances in the matter in respect of the eviction notices. Full stop. It has been further observed that if such individual representations are submitted by them within the time period prescribed therein, the same should be considered on merits and disposed of by separate orders issued in the light of the observations made by the Honorable Supreme Court of India in the order dated 3/12/2020.
3/2, my lord.
3/2, full stop. The learned counsel for the respondents, as Mr. Chaudhary, learned senior counsel appearing for the petitioner, has submitted that the instant petition be also disposed of in similar manner, the learned counsel for the respondents. Appearing for the respondents have submitted that as the petitioners herein are stated to be similarly situated like the petitioners in WBC number 4797/2023. The present petition can also be disposed of in the similar manner. Taking note of the observations made in order dated so and so, PIL, SLP, order dated so and so, passed in SLP, and order dated 2/1/2023, passed in WBC number so and so. This court is of the considered view that the case of the petitioner should be considered in the similar manner. Full stop. In view of the same, this writ petition is disposed of at the stage of motion hearing by allowing the petitioner to submit individual representations before the jurisdictional deputy commissioner, ventilating their grievances as regards the final eviction notice.
That's 8/12.
Final public eviction notice dated 6/12/2023 within a period of 15 days from today.
Yes.
Or date.
On a book before.
Okay, date. Mr. Chaudhary, tell a date. We'll fix the date. Not 15 days, fix a date. 15.
15 January.
15 January.
Hello, before 15 days will be on 5th of January. Okay.
Reasonable enough. Okay, 12 January. 12 January. Before Bihu.
Yes.
12/1/2024. Full stop. If the petitioners submit individual representations before the jurisdictional deputy commissioner on or before 12/1/2024, the jurisdictional deputy commissioner shall consider each of the representations on its own merits and thereafter, dispose of the individual representations by separate orders issued in the light of the observations made by the Honorable Supreme Court of India in the order dated 3/12/2020, passed in SLP number so and so. Full stop. It is further observed that until such time, the exercise sought to be carried out by the final
Notice dated 6/12.
public eviction notice dated 6/12/2023. Status quo shall be maintained in respect of the exercise sought to be carried out by the so and so till the as regards the possession of the petitioners over the land in question shall be maintained. This order disposes of the writ petition.
Item number 55.
Yes.
Lordship, this is against the eviction notice served to me, my lords.
Eviction notice.
Yes, my lords. My lords, I had been in possession of a 1 katha land in Pamohi, Gorsuk. My lords, I had applied for settlement of land through the Basundhara mission, wherein, my lords, it has been rejected on the ground that I have not been in the possession of the land. However, my lord, I have paid the TOSI also till 2010.
Okay, Mr. Goswami, you take instruction in the meantime.
Admittedly, he is in the government laws. That is.
Okay, but you take instruction. Third, Mr. M. Bormon, learned counsel for the petition, and Mr.
I'm for 2 and 3 laws.
I have 1. A. Bhattacharya, Revenue and Disaster, 1. N. Goswami, Junior Government Advocate, Assam, for the respondent number 2 and 3. Mr. S. Bora, standing counsel GMD for the respondent number 4. The petitioner has approached this court by way of, by the instant writ petition after he has been served with an eviction notice dated,
8/12, my lords.
where is that?
Page number 17.
8/12/2023 by the respondent number 3, whereby he has been asked to vacate a plot of land covered by government DAG number 515 situated at village Pamohi, Mauza Ramsorani within a period of 3 days. Full stop. As per the said notice, it has been served under Rule 18(2) of the settlement route framed under the Assam Land and Revenue Regulation 1886. Full stop. It is the case of the petitioner that the notice has been served, the impugn notice has been served on the petitioner after rejection of his application for allotment on allotment of the same plot of land, right?
Yes, my lords.
On
My page 29, my lords. 14 November.
14/11/2023 on the ground that the application, the petitioner is not in possession of the said plot of land, covered by DAG number, government DAG number 515. Full stop. The learned counsel for the petitioner has asserted that the petitioner is in possession of that part of the land covered by government DAG number so and so, in respect which the impugned eviction notice has been served upon him. Mr. Goswami, learned junior government advocate, shall obtain necessary instructions in the matter by the next date of listing. Please the case. Yes, fine.
On receipt, 6th of January.
Saturday.
8.
8, what is it? 10/1.
Copy by tomorrow, Lordship.
Copy by today. Mr. Borman, learned counsel for the petitioner, shall furnish 2 copies of the repetition along with annexure to Mr. Goswami during the course of the day, having regard to the time limit provided by the notice, impugn eviction notice, and the projection made on behalf of the petitioner. It is observed that till the next date of listing, there shall not be any process of eviction and the status quo. With regard to the plot of land reflected in the said impugn notice and the status quo as regards position as on date shall be maintained. You get the instruction, or you decide the repetition?
Much obliged, your lordship.
56.
May I please, your lordship. Lordship, this is a writ petition directed against for passing of the complaint that is pending before the 15th Metropolitan Magistrate 15th Court in Calcutta. Lordship, the fact is that the person is from Sibsagar.
Whatever be the facts, if you want passing, then the jurisdictional high court.
Lordship,
you cannot stretch the cause of action under 226(2) in that manner.
No, Lordship,
And
because
secondly, none of these respondents are public authorities.
Lordship, in the similar case, this honorable court has entered in.
We will go by the law.
Lordship,
we will go by the law.
The cause of action, entire cause of action has arisen in Sibsagar, and either they can file a case in Chennai.
Show me similar situation, Supreme Court.
Lordship,
by any of the decisions.
Lordship, there is a decision of Navin and Mazathia versus State of Maharashtra, where the cause of action, if the part of cause of action arose in a place, then that jurisdictional high court has the can entertain a writ for quashing. Lordship, because there the Article 226(2) was taken into consideration and this judgment was passed. And relying on that judgment, another judgment of this honorable court, wherein this is Mohammad Kadir Sasikant Prasad and Sri Ramakant Prasad versus Mohammad Kadir. This is of this honorable court. Navin Chandra is of the Supreme Court. Lordship, it is in para 6, para 18, where the cause of action has been described. And then in para 21, last part, the territorial jurisdictional part was considered. In para 18, and this regarding this similar finance company, this honorable court has stayed in WPC number 2017/2023. That copy I don't have, but I have collected a soft copy right now.
No, to whom will issue writ? The second question is, to whom will issue writ of such order?
To the 15th Metropolitan Magistrate.
Who is he?
Lordship.
Somebody as a
Then,
state.
Lordship, I will have to make the state of West Bengal a party.
You have to make a public authority.
Yes, Lordship.
That is the second question.
Yes,
That is, I have asked. Right. Otherwise, no writ lies against this.
Yes, Lordship.
Any of these respondents.
And because purely
That is also settled law.
They are
And
not deciding public duties. also.
Something where a proceeding is pending, an authority from that is to be represented.
Yes, Lordship, that state of
Is
West
it not?
Bengal, State Bengal, West
This
Bengal.
cannot be a writ with is not issued in without any target. Am I clear?
Yes, Lordship.
That is a lacuna I have found in this.
State of, my mistake is that I have not made state of West Bengal.
Now there is a procedure.
Yes, Lordship. I'll file a mistake.
Fill up that, we'll examine then.
Because
Fill up that lacuna. There is inherent lacuna in your petition.
yes, Lordship, that is there.
Okay, Mr. S.N. Tamil and counsel for the petition has sought for listing of the case when 4-1. 4-1.
4-1.
4-1
Yes, Lordship.
or 5-1. 5-1. 5-1. 2023. As he is he wants to examine about the requirement of filing additional petitions. Please the case on 5-1 as sought for by Mr. Kamuni.
Bail hearing via item number 30.
Yes, Mr. Public Prosecutor available.
NCB will be here.
Mr. Bhagavati, it is very difficult today. Difficult. We'll be having more bail applications someday else
Lordship, my senior is on leave, Lordship.
on legs.
On leave.
Because we'll be running short of time. If I decide the other bail applications will be.
No issue, Lordship, as court permits.
When we want. When
Lordship,
you
any
want.
day as fixed by
Okay, 9-1,
Lordship.
Tuesday.
Much obliged.
Okay, Mr. B. Bhagavati, Learned Counsel for the petition is present. Mr. S.C.K.L., Learned Standing Counsel, NCB,
Yes, Lordship.
is stated to be busy in another court. As
No, Lordship, he is on leave.
stated to be busy, but that it means on legs.
He is on leave, Lordship.
Okay, okay. Okay, he is on leave. That is a better ground. Is on leave and has sought MS
M Deca.
M. Deca, Learning Council appearing for SC Cal and standing of NCB has submitted that Mr. SC Cal and standing of NCB is on leave and has paid for listing of the case on another date. Full stop. Lays the case on 9/1.
Much obliged.
Bail hearing item number 32.
একটু গরম লাগিছে অলপ। Bail hearing.
CD receivers.
What is your ground? Tell me precisely.
My lord, two specific grounds, my lord. First is that there were three FIRs in all, my lord. In two of the FIRs, my lord, was granted bail by the learned courts below. Charge sheet has been filed in those.
That will not be applicable here in
the facts
for this court.
Yes, Lordship, and that is correct. I'm not saying parity of bail. My lord. I'm only saying that in the other connected two cases, my lord, the bail was granted and charge sheet has been filed. And I have appeared before the learned trial court and obtained regular bail, my lord, from the courts below. Second, my lord, that pursuant to your lordship's order, my lord, one of the other accused in the FIR, who happened to be a customer also, my lord, she obtained pre-arrest bail from this honorable court. Different bench, my lord. This order is there, my lord, 27th of July, 2022.
Is there absolute parity?
That, my lord, is a factual aspect of the matter, but the
which we have recorded here. Because
lordship's order is of
something has been explained but later on.
Yes.
Because there was one judgment of one paragraph in 2005 7 SCC similarly situated. Then that has been explained later on.
Yes.
That there should be absolute parity.
Yes, my lord. No,
Only in that case the parity can be urged.
that is true, my lord. No doubt. I cannot, my lord, say that.
Yes,
but the
but-
fact remains that the named person in the FIR, there were 4 or 5 named persons. Among them, my lord, to our knowledge, one of them has obtained bail.
Otherwise, law on the second application. Law on the second application.
My lord, as far as the second, this application, my lord, 2 years passed, my lord, after I got interim bail, my
Is
lord.
that a ground? Cannot be a ground.
My lord, that is not the only ground.
Legal ground. That cannot be a legal ground.
No, that is correct, my lord. That cannot be the only ground.
What is there?
As per CD Lordship, some more complicated statement has come up, Lordship. The vigilance officer has now again implicated him, Lordship. The co-accused person has implicated him again, Lordship. So, Lordship, and release on bail or granting of bail to the co-accused is not.
Who is the co-accused?
That is Sunita. Lordship.
Sunita Kumari Rai. She was.
But she was the customer, Lordship. She was the customer. He is the bank officer, Lordship. This person is a bank officer, Lordship.
She is
And
not
he has
only the
seen
customer.
Outsider versus insider.
No, my lord, she is the kingpin. My lord.
Otherwise, you were insider.
I was inside, my lord, but Sunita Kumari Rai was as much involved, my lord, as I was. If the allegation in the FIR is correct, because the bank has only
Sunita
informant bank.
Kumari on her own could not have done this.
No, not on her own, my lord. There are other persons also involved. There's no doubt about that, my lord, that part of the matter. But my lord, considering,
What
my lord,
else? Let me see. Just identify.
No, other co-accused person statement is also there. This is other co-accused person.
126. Number is 126.
Well, there were 6 named persons in the FI. I am one of the 6 named persons. Your lordship sees the allegations.
The records reveal now,
Lordship,
records have revealed now
lordship.
that you have opened 126 number of bank accounts with only your mobile number.
Yes, that is admitted. That is.
No more, nothing
good
is
position,
required.
Lordship.
Hard, Mr.
As a
Ganguly. Learned counsel for the petitioner and Mr. P.S. Locker, learned traditional public prosecutor for the respondent state of Assam. By this application under so-and-so, approached this court seeking the benefit of so-and-so after rejection of his previous bail application, AB 71/2021 by an order dated 2/8/2021 after perusal of the materials in the case diary. As the contents of the concerned FIR lodged in connection with Tezpur Police Station case number 2245/2020, where aptly reflected in the order dated 2/8/2021, the same is reproduced here in paragraph 3. Mr. Ganguly, learned counsel for the petitioner, has submitted that a co-accused named Sunita Rai has already been extended the benefit of 3 years bail. Full stop. He has further contended that the petitioner who has been implicated in 2 other crime cases, VIJ, what is the case number?
Lord, Tezpur PS number 363 of 2020 and Tezpur PS case number 2245 of 2020.
Has been extended the benefit of 3 years bail in connection with those 2 cases. As he has further contended, as a period of 2 years have elapsed since the rejection of the previous bail application, the investigation of the case must have progressed considerably, and as such, at this stage, there would be no impediment to extend the benefit of 3 years bail to the petitioner. Mr. Lockwood and additional public prosecutor for the respondent state who has been asked to obtain the up-to-date case diary, has produced the same and has submitted that the investigations carried out after 2/8/2021 has revealed further incriminating materials against the petition. When the previous bail application preferred by the petitioner was considered on 2/8/2021, the materials in the case diary produced on that day were perused and it was recorded from the materials found available in the case diary that some of the customers of the bank had submitted their KYC documents to the bank in the year 2018 as they wanted to apply for loans from the bank. Full stop. After submissions of their documents, the petitioner never informed them regarding their loans. And it was in the month of October 2020, those customers came to know that their loans were running in their names in the bank. Full stop. It was during bank's investigation carried out thereafter, it was found that the customers had never signed the loan application forms and they did not receive any amount. Full stop. It was further revealed that the loans were processed using one particular common mobile number. Full stop. The case diary produced, the materials in the case diary produced today by the learned additional public prosecutor have been perused. Full stop. From the materials in the case diary, it is revealed that the petitioner had utilized, had persuaded the customers of the bank to open their account by using his personal mobile number, and 126 number of persons, loan accounts of 126 number of customers were opened using the mobile number of the petitioner, one particular mobile number of the petition. The case of the petitioner cannot be considered on the principle of parity, as the co-accused Sunita Rai was not an employee of the bank. Full stop. The co-accused was an outsider, whereas the petitioner was an insider who had the, without whose involvement, loan accounts of in such large numbers, that is 126 numbers, could not have been processed and amounts could not have been released without any involvement of the petitioner. And such view of the matter, the principle of law as regards second bill application, having regard to the above situation obtained in the case, this court finds the instant application of the petitioner preferred for the second time, not merited, and accordingly, the same is dismissed.
Lord, these observations only for the purpose of bail, that your lordship may say.
Anyway, there is law.
Let it come on record. That one line.
It is, however, clarified that the observation made herein is only for the purpose of considering the pre-arrest bail prayer of the petitioner, and the same shall not be construed as observations on the merits of the case for the purpose of trial.
Item number 34.
CD not received, lordship.
CD not received.
He is an interim, lordship.
Huh?
He is an
The
interim.
learned counsel for the petitioner. Yes, not received. MSRDB learned counsel for the petitioner is present. Mr. P.S. Doctor learned additional public prosecutor has submitted that the concerned case they call for, has not yet been received and has sought for listing of the case when?
On 9/1.
9/1/2023. To enable him to produce the concerned case diary, list the case accordingly on 9/1/2023. The interim order passed earlier shall continue till the next listing.
35.
Yes, medical report statement. What is the allegation?
It's
There has been He has been extended. Interim bail.
Yes, Lordship.
What is the allegation?
POXO is there, Lordship.
FIR.
Page number 17.
I have the honor to report you that the accused, namely Abdul Latif, used to work at our institution academy in the Department of Constitution. It has come to light on 27 that some You are Mohibul Mondal.
Yes, Lordship.
You are not Abdul Latif
No,
Ahmed.
no, Lordship. I'm apprehending
Who are
because
you?
of page number 20.
Huh?
I'm apprehending because of page number 20. Lordship,
20.
kindly see page number 20. The petitioner is a reporter, Lordship. Because of this, his Facebook post, he's apprehending.
That could be at best a case of defamation.
Yes, sir.
Huh? Anything more, Mr. in the case diary?
Lordship.
Huh?
Because Lordship, this is the person who has published all these photos on and in the Facebook, Lordship. So,
Photos?
Photos and objection.
Photos, revealing photos or not non-revealing photos?
Photograph is there.
Photographs, I don't know, that is not other photograph
my
not
Facebook
come,
post,
but he
Lordship.
himself has stated in his 161 statement, Lordship, that there are some objectionable scenes and photos. That is there, Lordship. And other person also, some witnesses has implicated him that this person has communicated all these photographs to the other so many persons, Lordship, in WhatsApp group, Lordship.
So it would be a case of IT Act.
Actually, it should be
Now, if under what provision of IT Act?
67. It will come, Lordship.
67? B.
B.
And whether that is bailable or not bailable?
Bailable.
First offense is bailable.
Bailable.
First offense is bailable.
That offense is bailable.
Bailable.
Then, otherwise, he is not POXO.
No, Lord.
He is not.
Not 376.
No, Lord.
Not 354.
No.
Whether he has appeared or not.
He appeared. That is his statement, Lordship.
No, otherwise, if the IT Act is bailable and this offense is only relatable to him, otherwise, he is not involved with 376 activities or 354 or POXO activities.
That allegation is not there
Not there.
against him, Lordship. But
If the 67 is available and option is available to the lady, to the LS chemistry teacher and the institution
but it
to
would not come back.
initiate defamation proceeding in the criminal side as well as from the civil side. So for
Yes.
67 is concerned, if it is bailable,
There was some, as per CD Lordship, there was some physical relation with that teacher and the victim guard, Lordship. But that has been published, and that has been published by this person, Lordship.
right? So,
Otherwise, it would not come
so
in.
does it come under POXO Act?
Also, Lordship.
From POXO Act?
My other submission is that, Lordship, no.
Wait, let me examine the, let me get the queries from public prosecutor.
Yes, Lordship.
IT Act কোনো দিয়ক। What is the offense? 4789. 4. Penetrative sexual assault, not attracted. 6. Aggravated penetrative sexual assault, not attracted. 7. Punishing clause, penal clause. 8. Punishment clause. What is the definition? Assault.
Section 7.
Section
7, Lord. 7 is the
7.
definition, 8 is punishment.
Huh?
Section 7 is the definition, Lord.
Definition.
Definition, Lordship, 2I. 2I. has the same meaning as assigned to it in section 7.
POXO is not attracted. It requires something more. Then 376, 354 also. Now 67B. I'm not in touch with these provisions. That is why I'm asking. Punishment for publishing or transmitting of material depicting, okay. Where is the penal provision? Where it is defined, these provisions are bailable, non-bailable? Otherwise, first conviction, 5 years. 5 years, right? It says that only up to 3 years it is bailable. Since he has appeared, let him go. Heard Mr. M. Ahmed, Learned Counsel for the petitioner, and Mr. P.S. Lockwood, Learned Additional Public Prosecutor for the respondent state of Assam. The petitioner has approached this court, so it's going to 438. In connection with Likidibo to what is the police station? South Salmara Police Station, case number 217/2023, registered for offences under 376, 354, IPC RW sections 4, 7, 8, 9. Stroke 21. Comma, Oxford number 12. RW 67B, Information Technology Act 2000 as amended. Full stop. As per the first information, the first information report was lodged by the managing director of one Yan Vikas Academy, Hatsingmari, alleging inter alia that some objectionable photographs got viral on social media reflecting involving one Abdul Latif Ahmed, an assistant teacher in the said educational institution, along with 2 girls. Para. The petitioner is not named as an accused in the said affair. It has, however, been revealed that the incident involving the teacher of the said educational institution had been circulated by the petitioners in the social media. Full stop. In the post so circulated in the social media, from the post circulated in the social media, it does not go to indicate that the petitioner has named any person in the said post uploaded in the social media. Full stop. Para. The petitioner has been provided with interim protection by an order dated 15/9/2023. With the further condition that the petitioner should appear before the investigating officer of the case within a period of 7 days from 15/9/2023. Full stop. Mr. Lockhart, an additional public prosecutor who has produced the case diary, has submitted on the basis of the materials in the case diary that the petitioner in compliance of the direction made in the interim order dated 15/9/2023 has already appeared before the investigating officer of the case. Full stop. From the materials in the case diary, it does not go to indicate that the petitioner, there is any involvement of the petitioner in respect of the offenses registered under the provisions of the Indian Penal Code and the POCSO Act 2012. So the only allegation against the petitioner is in respect of the offense under Section 67B, Information Technology Act 2000 as amended. Full stop. As the petitioner has already appeared before the investigating officer of the case and is assisting and has thereby joined the investigation, the custodial interrogation of the petitioner is not found necessary for carrying out further investigation of the case, provided the petitioner continues to extend his assistance and cooperation in the further investigation of the case. Accordingly, the interim protection granted to the petitioner by order dated so and so is made absolute, subject to the conditions appear as and when, cooperate, and appear in the trial if charged.
Item
Is
number
diary produced by Mr. Learned Additional Public Prosecutor is returned herewith.
37.
Received
Not received. He's an interim lordship.
2 and 3. Mr.
K. Zaman.
A. Rahman.
K. Zaman, Lordship.
K. Zaman, Learned Counsel for the petition. Heard. And Mr. P.S. Lawford, Learned Additional Public Prosecutor for the respondent state of Assam. Case there he has called for. Has not been received. And yes, when?
On 12 lordship. 12.
12/1. Negative. Place the case accordingly on 12/1. The interim order passed earlier in favor of the petition number 2 and the petition number 3 shall continue till the next date of listing.
38.
Yes, case diary.
Is it?
What to do then? There is no representation on behalf of the
There's the
petitioner
second
to be on
disposal.
call. Mr. P.S. Lockhart, an additional public prosecutor for the respondent state, has submitted that case diary along with medical report. Medical report?
Medical report comes lordship, but he has no any involvement lordship.
Huh?
This person has no any involvement.
Because it was called for.
Honestly.
Okay, has been received by him. In view of non-representation on behalf of the petitioner today on call, let the case be listed on 5/1, 8/1, 2023. The case diary so received, be retained till the next date of listing.
Item number 40.
May I please, Your Lordship? In here, Your Lordship, page 14 is the FIR, Your Lordship. Yes.
Received.
CD received lordship.
Yes.
Yes, 14 is the FIR, Your Lordship.
14 is the FIR.
Lordship, in this case, we have received the CD lordship, but some updation is required lordship because lordship, we cannot say anything from the only the complaint statement is here lordship, and we cannot say what is the progress of the investigation, nothing is there, Lordship.
But basically herein allegation is that your lordship, two motorbike were purchased by the informant and the same was given to the petitioner. Because the informant and the petitioner were in relation, your lordship. And subsequently, the motorbikes were.
It is in the same line as in the statement, as in the affair.
Lordship,
A statement,
same,
they were in relation.
Lordship. As per her allegations, he has sold her bike.
And
bike
both of them went to the dealership.
Lordship,
Huh?
Lordship.
Then informant permitted to purchase the two-wheelers in her name. Then relationship may have turned sour. It is not that
I can appear before the IO in the.
you have heard Mr. A.M. Khan, learned counsel for the petitioner, and Mr. P.S. Walker, learned additional public prosecutor for the respondent state of Assam. 438, Poltamada police station case number, huh? In the FIR lodged by the informant on 29/4/2023, it has inter been alleged, it has been stated that the petitioner, the informant and the petitioner were in a relationship for about 1.5 years. And there was an assurance from the petitioner to marry the informant. Full stop. It has entirely been alleged that the informant in the month of January 2023 has been persuaded by the petitioner to purchase a two-wheeler in the name of the informant by availing a loan in the name of the informant herself. It has also been alleged that again in the month of February 2023, the informant has been persuaded by the petitioner to purchase another two-wheeler in the name of the informant. The informant has further alleged that has stated that both the two-wheelers have been purchased in the name of the informant after obtaining loan facilities from a bank. After purchase of the two-wheelers, both the two-wheelers, the same were handed over to the petitioner, and the petitioner had used and had kept on using the two-wheelers without returning them to the petitioner, despite request from her end. As a result, the petitioner informant has been continuing to pay the EMIs against the loan facilities obtained for purchasing the two-wheelers. Any other allegation? No. Mr. Additional Public Prosecutor, P.S. Walker, who has received the case diary, has submitted that apart from the statement of the informant recorded under section 161 CRPC, there are no further materials in the case diary, and further investigation of the case is necessary in order to find out about the culpability of the petitioner. Full stop. From the contents of the petition, FIR lodged against the petitioner, as briefly narrated above, the two-wheelers were purchased in the name of the informant only, and the petitioner and the informant were known to each other since about 1.5 years earlier. Full stop. What is your case?
My case is that, your lordship, the bikes are still in her name, your lordship. The
The
17 and 18.
petitioner has asserted that the two-wheelers are still in the name of the, still registered in the name of the informant, and as such, no prejudice has been caused to the informant. Full stop. Having regard to the allegations made in the FIR and the projections made in the on behalf of the petitioner in the aforesaid manner, this court is of the considered view that there appears to be no necessity for custodial interrogation of the petitioner, provided the petitioner extends his assistance and cooperation in the further investigation of the case by appearing before the investigating authority as and when his presence is called for. Full stop. Accordingly, extending so and so, 30,000, 1 COT, IO, 10 days, or as and when his presence is called for by either condition.
41.
Is there received?
CD not received.
Not received. There is no representation on behalf of the petitioner today on call. Mr. P.S. Locker and additionally public prosecutor has submitted that the concerned case day as called for has not been received. List the case. On 12/1/2024 for production of case diary.
For 41.
Any other?
142, I think is there in orders.
That has been,
Mentioned.
No, it will be.
Orders are the 42 items.
that has been mentioned.
Order, oh no, admission item number 14.
Mentioned, mentioned is, 41?
42 is mentioned.
Oh, 42.
42,
Okay.
42.
May I please your lordship?
41 has been mentioned.
May I please your lordship? Your lordship, this matters relates to inaction on the part of the GMDA and GMCA, your lordship.
Which item?
And
For admission item number 14.
the last occasion also, GMDA and GMCA was directed to file the affidavit, but till now they have not filed any affidavit, your lordship.
Records show that GMDA has not filed any affidavit.
Your
Yes,
sir,
where is Mr. GMDA? Nayok, Bora.
Your lordship, GMD has already taken steps, your lordships. Examination notice has already issued against me.
For what purpose you have prepared this petition?
Inaction on the part of the GMCA for not taking
Direction
steps.
shall not be issued asking the GMC to take complaint by the petition being carried out by the primary causing damage to the petitioner's life and continuing that. If notice has been issued, let that proceeding be brought to a logical conclusion and you should be provided with adequate opportunity of hearing. Let us see. Call Mr. Standing counsel from
Your lordships,
GMDA.
against this notice of demolition, your lordships, I have already prepared an appeal on the GMDA before the session court, your lordship, it is pending. So this writ petition is already in practice, your lordship.
Here also the GMD have not appeared and not filed anything.
That is for the GMDA too. If they do not appear, are you made a party? Are you made a party in the appeal?
Appeal I have not filed. They have.
They have.
I have made, your lordships.
You have made a party?
Yes, your lordship, he is also the party.
Oh, you are a party?
Yes.
Participate in that proceeding. This is by the provisions of GMDA Act. Please call somebody from GMDA. Hard MS R Begum. Well, counsel for the petitioner. Mr. N. Goswami. Learned Junior Government Advocate Assam. For the respondent number 1, Mr. Learned Standing Counsel GMC and GMDA. For the respondent number 2, 3, and 4. And Mr.
Ananja, your lordships.
Ananja. Learned Counsel for the respondent number 5. As per the case projected in this writ petition, preferred under Article 26 of the Constitution of India, the petitioner and his family have been residing in a plot of land measuring 5 lesses covered by number 368 and Patan number 105, secured at village Sohor Choronia, Part 1, Moja, Ulubari, District, Kamrup Metro. Guwahati Revenue Service. Which has been mutated in their names, since long. The respondent number 5 states in a plot of land, adjacent to the plot of land of the petition. Full stop. Both the petitioner and the respondent number 5 are using the same approach road for ingress and egress to their respective residences. Perhaps when the respondent number 5 started constructing an RCC building in his lot of land from February 2022, it was noticed that the wall and the roof plinth of the under construction RCC building stood extended to the edge of the plot of land of the petitioner, thereby, leaving no space and gap between the between the house and the wall, boundary wall, and as a result, water from the upper floors of the building constructed by the respondent number 5 had the possibility of falling beyond the boundary wall and inside the plot of land of the petition, right? Full stop. The petitioner stated to have lodged a complaint before the respondent number
Commissioner GMC.
2 as well as the respondent number 3. Full stop. When no effective steps were found to have been taken by any of the said two authorities, the petitioner. It has been stated that the petitioner has been constrained to institute the present petition. Full stop. Fair. GMDA, GMC. Okay. Mr. Jha, learned counsel, who has appeared for the respondent number 5, has placed a copy of an order bearing number so and so dated 1/3/2023, issued by the respondent number 3, to submit that. Who is Kutubuddin?
Private respondent number.
Respondent number 5.
To submit that the respondent number 5 was already served with a notice dated 21/7/2023 under Section 88 of the Guwahati Metropolitan Development Authority Act 1985, asking him to show cause as to why the deviated portion of the RC building constructed by him should not be dismantled due to deviations made from the approved drawing and the NOC issued by the respondent GMDA on 7/8/2006. Full stop. The deviations found in constructing the RCC building were also reflected. Full stop. The order dated 1/3/2023 has further revealed that when the respondent number 5 submitted a reply on 9/2/2023 in response to the notice under Section 88 of the GMD Act 1985, the same was examined. And after examination, the same was rejected. Full stop. An order had already been passed by the respondent number 3 on 21/7/2023 to the respondent number 5 to remove the unauthorized part of the construction. Full stop. By the order dated 1/3/2023, the respondent number 7 has already been directed to demolish the unauthorized portion of building, constructed in violation of the provisions of the approved building permission and building bylaws within a period of 10 days from the date of receipt of the order dated 1/3/2023. failing which the GMD authority would proceed with the demolition of the unauthorized part of the construction or would seal the premises of unauthorized construction. Full stop. It is submitted at the bar. Kera. By Mr. Jha, learned counsel for the petitioner that against the order dated
Respondent number 5, Your Lordship.
Respondent number 5. That against the order dated 1/3/2023, the respondent number 3 has preferred an appeal.
Respondent number 5, Your Lordship.
Sorry, 5. Preferred an appeal before the appellate authority, that is
Additional District Judge, Kamrup Metro.
basically district judge.
District Judge.
Before the appellate authority, district judge, Kamrup Metro, as per the provisions of the GMD Act 1985. Full stop. On preferring the appeal, the appeal has been registered and presently, the said appeal is pending before the court of said appeal. Any number?
Miscellaneous Appeal number 5/23.
Said appeal being miscellaneous appeal number
5/23.
2023 is presently pending before the court of learned
Additional District Judge, Kamrup Metro, number 5.
number 5. So Mr. Jha has further submitted that the petitioner herein is a respondent in the said appeal, right?
Yes, Your Lordship.
And has already started participating in the proceedings of appeal number so and so, right?
Yes, sir.
The fact that the petitioner herein is a respondent in the pending appeal number so and so and has been participating in the proceedings before the learned additional district judge so and so have not been disputed by MS Begum, learned counsel for the petition. Full stop. As the in view of as the complaint regarding of the petitioner regarding unauthorized construction of the RCC building on the part of the respondent number 5 has already resulted into the order dated 1/3/2023 of the respondent number 3, there no cause of action appears to have survived for the writ petitioner to continue with the present proceedings. Writ proceeding. Full stop. As the order dated 1/3/2023, whereby the respondent number 5 has been directed to demolish the unauthorized portion of the RCC building, has been at the stage of appeal as on date, before the appellate forum, the remedy of the petitioner lies in participation of the in the ensuing appellate proceedings presently pending before the appellate forum of learned additional district judge, Kamrup Metro, Guwahati, number 5. Number 5 to agot ahib. Full stop. Since the petitioner has already started participating in the said appellate proceedings, this writ proceeding is found to be a parallel proceedings, which is, which cannot be allowed to proceed. Is a proceeding, parallel, which cannot be, allowed to be proceeded simultaneously with the appellate proceedings. Accordingly, the petition is closed, reserving the liberty to the petitioner to hesitate all the points regarding unauthorized construction of the RCC building before the appellate forum.
Item number 18.
In this case, affidavits are exchanged, my lord. Can it be taken up on reopening, my lord?
What is this unauthorized construction?
Lordship.
No, my lord, I have.
Unauthorized construction carried out by the respondent number 6.
Construction has been made in my land, my lord. They have
But lord-
stated that we have not kept the required setback. my lord.
Without
That's
the-
the only case.
Okay. Pleadings are exchanged.
Yes, my lord.
Choose a date after Bihu.
My lord.
On 10th, Lordship.
That will be crowded. There will be long list. This is of 2023.
My lord.
It will come in the bottom. Let it be on 24th.
Lordship.
My lord.
Heard Mr. R. Pukon, Learned Counsel for the petition, and Mr. P. Shundi,
My lord. For respondent
Learned
number
Counsel
6.
for the respondent number 6. Also heard. You were there.
For Tezpur Municipal Board, none has appeared, my lord.
Mr. N. Goswami, Learned Junior Government Advocate Assam for the respondent number 1 and 2. Full stop. It is submitted by the Learned Counsel for the parties that exchange of pleading is complete, and the matter be listed for admission after the ensuing winter vacation. Full stop. List the case on 24.
Much obliged.
Offline.
19.
Yes, Mr. Amar, we are also running sort of this rails came. Yes, somebody, something else. What is the case about?
My lord, we have a bricks industry and they complain that the environment is polluted by their industry. Whereas we are.
You have a big industry.
I am-
You have a big industry.
Yes, I am Rita Ashwikia, petitioner. But our industry is running since 1985 and they have started their bakery in 2019. Now they're raising the objection regarding this being influenced by some other persons.
And what is the impugn order you are challenging?
That lordship may kindly see page 30,
No, but basically stoppage.
page 36.
You have been stopped from operating.
Even stopped, but interim order is not extended. Last time it was registered, not extended.
Okay, sorry. It will be extended, otherwise it has missed.
Yes.
No, my lord, I have objection because last time it was not extended.
It will be extended now.
But once it is vacated, it is.
Not vacated, it was
No,
simply ordered.
My lord, what my submission is this, once at that time they did not pray for extension, I think that.
What is the interim order?
Interim order was there not to, correct.
Not to
things are
operate
there.
machine. 3 to.
I'll see the last order. Now, once that is not there, whether the next day.
Board has the power, it has
Board has
missed,
power,
it has been missed.
But power should be exercised in accordance with non-sources of
No,
law.
you are the petitioner,
Yes.
you are enjoying the interim order.
No, interim order, because that interim order.
No, then we'll extend, this is not a submission.
That will let short
me know
may be fixed for final hearing.
Learned Counsel for the petitioner and Mr. MSP Bharat
For respondent number 7. Lordship.
7. And
And for
What
2 and 3, Lordship.
Huh?
2, 3, and for 2 and 3.
or 2 and 3. Forest. Forest also is there.
Yes, respondent number 1.
Nobody. Yes, madam. As Burwa. Pollution Control Board, 5 and 6. And MSP Bharat 7. Okay. As sought for by the Learned Counsel for the parties, as agreed to by the Learned Counsel for the parties, this is the case on 18-1.
For final hearing.
18-1. In the admission column, the interim order passed earlier shall continue till the next.
Right.
Any interim order to be extended, please tell me. No other prayer. No other prayer.
Item number 20 and 21, my lord, there is a small issue, my lord, regarding no confidence motion, my lord.
It
This
cannot be
honorable,
before vacation.
Lordship, this honorable court set aside the resolution, my lord.
Tell
But,
me a date, propose a date only.
Lordship, kindly see that annexure 1, my lord. Date, any date, today or
কোন দিনে কম আছে সব? Any interim order?
no, my lord.
কোন দিনে কম আছে? Huh?
On Friday.
No
my lord.
confidence.
Oh, yes, my lord, on Friday, my lord, my.
What Friday? I'll post it in March, month of March then.
Otherwise, my lord, it was infructuous, my lord.
12. 12. Release the case on 12. Release the cases on 12. Item number
2021, my lord.
20.
T21.
Item number 61, lordship. 61, I was filed, lordship, to, there are some typical errors in the order of the lordship.
Mr. Kolita, it is very difficult now.
Sir,
I have to,
yes, lordship, but
it is not that,
then lordship, on Friday, lordship,
not Friday. If
Correction of
something
the-
is available on 3rd of January.
3rd of January, lordship.
Which one?
61.
61. Likhi dibo 3rd of January. List on 31.
Lordship, in the item 47, Lordship, matter need to know from some motion, Lordship. Earlier it was 4 times left, also Lordship, fixed it
No, wait.
on 3 of 5th, 3rd of 5th, Lordship.
No. Already crowded. Already.
Otherwise, also services complete.
Already it will go up to 100 if we go on fixing on 3rd of January.
On 5th, Lordship.
Already fixed. More
On
than
fifth-
50.
On 5th, Lordship. Then, Lordship.
10.
Then what?
With your lordship, in
List
item
on 10.
number 25 and 26.
Huh?
In item number 25 and 26.
What is the subject?
Lordship, in this matter, the petitioner's house is in the threat of being collapsed due to landslides and due to the excessive earth cutting activity done by the private responder.
Meaning thereby it is on hill.
Yes, Lordship. Lordship,
Get
the
a
pleadings have
review,
been completed.
Let the review.
Much obliged, Lordship.